Gita Subramaniam and others.
Okay, thank you. Yes.
Your Lordship, my learned friend has an arbitration. So I
No,
think,
that's fine.
he will, because I have already stated my arguments, I might add one.
Yes.
But other than that,
We'll be short then. We'll be short then.
Yes.
I will take some time because I will go
Oh,
through the
achha.
Indian global judgment. So he will finish the arguments otherwise.
Huh.
And then I will just respond because then I have his judgments to respond also.
Very good. I have no problem.
The line of the argument which you made yesterday, that will be the only line.
There is only one addition.
Give
to
me
that.
the points in short so that we can just take a gist and he can argue on that.
Your Lordship, I have made a brief notes of arguments.
Oh,
I'll
yes.
give a copy to my learned
Give a
friend
copy
also.
to him.
I will share the copy.
I'm going to
ठीक है, no problem.
I have not completed it, Your Lordship. That's one point which I
No, definitely will come.
yes.
So do you want to indicate that point so that we
I will just indicate that.
I think
point.
that will be better.
Yes. The only additional point is I'll not stress too much because Your Lordship was not with me on limitation. I will not stress too much
Not
on
that.
limitation. Yes, I'll not stress too much. But otherwise, the point is that this is a public charitable trust. One of the parties is a public charitable trust. The trust has not been made a party. That's one. Order 31 says that trustees also have to be made a party. That doesn't mean the registered trust will not be made a party. So that has not been made a party. So this suffers from misjoinder. That's one. And the second point is with respect to the charitable trust, though otherwise the Trust Act does not apply, the judgments of this High Court are very clear that the provisions of the Trust Act and the principles thereunder will be made applicable under Section 7 of the Charitable Trust Act of 1920. In that regard, what happens is when there is a transfer of any kind of immovable or otherwise properties, which I showed yesterday, what the main purpose of it, then the permission of the court is required. So there is anyway no question of an arbitral reference deciding on that point. Anyway, they have to go to a principal court. I'll show the judgments on that point.
Typographically.
This is the only addition.
Lord,
Yes.
4 essential points Lord argued. First is on the requirement of a certified copy or the original accompanying a Section 11 application. First, my lord, the first issue, in fact, I had indicated to my learned friend that Section 11 subsection 10 has been repealed and the High Court rules were in terms of Section 11 subsection 10. But that is a wrong, my lord, argument and a wrong understanding because we checked up yesterday and that the repeal notification has not been notified.
2019.
2019. That is a
2019 amendment, yes, right.
It is
That has
applicable.
not.
I just wanted to say this, my lord, to clear if somebody, my lord, else suffered from the same misconception that I did. So that was a mistake. It is applicable completely.
Yes, yes, absolutely.
Now, Section 11 does not have the same requirements as Section 8. There is a distinction. First, my lord, is your lordship's judgment in Rupa Mukherjee.
I was apprehending that. But I'm open to that. Very well, yes.
Thank you.
Yes.
My lord, page 3. Fourth paragraph, a scrutiny of the provisions of Section 8 clearly indicates that subsection 1 thereof stipulates that the judicial authority before which an action is brought shall not refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. Section 8.2 contemplates that the application referred to in subsection 1 of Section 8 shall not be entertained unless it is accompanied by the original arbitration agreement or a duly certified copy thereof. It is thus clearly seen that the authority referred to in Section 8, subsection 1 is a judicial authority. However, in view of the well-settled principle as laid down in Vidya Rolia, and as per Section 11(6)(a) of the 1996 Act, the scope of consideration by the High Court under Section 11 of the 1996 Act is extremely limited. Hence, it is doubtful whether the orders passed under the said provision are judicial orders. As such, it is debatable whether this court can be referred to as a judicial authority within the contemplation of Section 8, subsection 1. More importantly, subsection 2 of Section 8 clearly refers back to subsection 1 thereof. As such, it cannot be said that the same rigor is applicable to a Section 11 application as well, particularly in the absence of a provision in the latter section. Hence, the provisions of Section 11 do not contemplate any such bar. There is no reason why the rigor imposed on Section 8.2 should be imported thereto. My lord, if your lordship looks at Section 8.2, which your lordship obviously has, there is a negative language, my lord, couched. There's a negative imposition couched in the language used in section, shall not be entertained. In the absence of such negative language in Section 11, perhaps the bar does not apply. That's not my first submission. Second submission is a more reasonable submission, perhaps, that if at all an issue like this is raised, this is a curable. If at all your lordship finds that it's not there and it's required, my third submission would be it's not required in this case at all. But my second submission is if at all your lordship feels that there is a necessity.
Do you have the original?
I'll submit a certified copy.
Well,
I would have if this point had been taken, my lord, in the affidavit. But I can, my lord, since it's taken in argument, because certification is done by us.
that does not mean I'll permit him.
I'm not saying
Is
that.
everything
Your lordship,
subject
the
to-
thing is that there is no affidavit at all in this
Yes,
case.
so
No,
So-
definitely not.
So
let
that's
us
my-
just
and-
understand the contours of his case.
Yes.
Right? Yes.
apropos that, my lord, I wanted to cite 2006 volume 2 SCC 777. My lord, this was a case where, my lord, after the amendment to the Civil Procedure Code, an affidavit was required to be filed along with a plaint. This had, my lord, come about the same time as we did, early 2000s. Now, my lord, there was a plaint filed without an affidavit. In view of Order 4, Rule 1, it was, my lord, argued that the plaint is deemed not to be instituted. By which time, my lord, a learned single judge had been pleased to pass an order of mandatory injunction. In the appeal from such order, my lord, there was a wall, a partition wall in an immovable property broken down, and there was a mandatory injunction for rebuilding of that wall. In appeal from that judgment, my lord, before the division bench, this issue was raised, and my lord, the division bench was pleased to come to the conclusion that the suit is not deemed to be instituted. So you may cure the defect now, but the suit will be deemed to be instituted now. So the judgment goes, the order goes. Matter went to Supreme Court. Supreme Court, my lord, paragraph 49 of this judgment. Kindly, if I may read paragraph 49.
Sure.
In this regard, we are inclined to agree with the consistent view of 3 chartered high courts in the different decisions cited by Mr. Mitra that the requirements of Order 6 and Order 7 of the court being procedural in nature, any omission in respect thereof will not render the plaint invalid, and that such defect or omission will not only be curable but will also relate back to the date of presentation of the plaint. So, my lord, this is at best, my lord, an omission which is, my lord, procedural in nature. So, my lord, if your lordship finds that it was a requirement, I undertake to file a certified copy within, my lord, 24 hours. Third argument. This is again relying on Section 8 cases. A respondent in a Section 11 is only entitled to take this point where he disputes the arbitration agreement. It can't be that you admit the arbitration agreement somewhere else or in the same proceeding, and you come back and say that no, why didn't you file a certified copy? There are two judgments, my lord, of this
No,
honorable
Mr.
court.
Chaudhary, we are at the pre-affidavit stage. So can you show from anything that they have admitted
Yes,
it?
the section 9, my lord, which is why, my lord, while moving, I had referred to a paragraph of the section
Yes, you
9
had.
petition and the opposition. This is what I had in mind. Now, my lord, there are two judgments. One, my lord, of 2009 and the other of 2011. 9 ta aage rakha tha na? Acha, theek hai. My lord, the 2000 in chronology, my lord, the 2009 judgment first.
Yes.
Second page, my lord. The requirement under the rules of procedure. Second page, second last paragraph.
Yes, got it.
I'm sorry, let me go two paragraphs before that. In the instant case, it is the contention of the petitioner that the original arbitration agreement is with the respondent. The respondent cannot take advantage of its own wrong and now contend that the application should be rejected only because the certified copy of the arbitration clause has not been annexed. Unlike section 8, subsection 2, which provides that an application referred to in subsection 1 for reference of a dispute shall not be entertained unless it is accompanied by an original arbitration agreement or a duly certified copy thereof. There is no bar under section 11 to entertaining of an application which is not accompanied by an original arbitration agreement or a certified copy thereof. The requirement under the rules of procedure to file an application under section 11 along with the original arbitration agreement or a certified copy thereof may be waived by this court where the arbitration agreement is admitted. So, my lord, here there's a direct, my lord, admission.
Rules of procedure take care of the scheme.
Yes,
Rules of procedure?
is the scheme. That's the only imposition.
Yes.
The National Stock Exchange scheme. Under the National Stock Exchange rules, these they were talking about. This is not with regard to the Chief Justice guidelines.
But the rules were there then because the rules are of 97.
Yes, but it was not noticed in this judgment, Your Lordship. So they are talking about the National Stock Exchange rules.
I'll just read it more carefully, my lord.
That's what appeared to me, Your Lordship.
Dekha na kotha.
So when your turn comes, Mr. Sinha, just point out. Point
Yes, yes.
in your reply.
My learned friend is right that the National Stock Exchange rules are, my lord, considered, but perhaps, my lord, those rules I'm not sure whether they require filing of an affidavit. I would imagine, my lord, perhaps subject to correction, that it is the section 11 rules because this refers to section 11. National Stock Exchange rules perhaps would not refer to section 11.
In any earlier portion of the judgment, the stock exchange rules have been referred to. Regulations have been.
Yes, stock exchange trading regulations of the National Stock Exchange of India
We can look into
Limited
the
Capital
context in
Market.
which we can look into the context in which it was
Yes,
looked
but
into.
and this paragraph itself, the requirement under the rules of procedure to file an application under section 11 would perhaps refer
Section
to
11 cannot be governed by stock exchange
stock
rules.
exchange rules.
And in any event, I'll have to go through the entire thing.
Yes, my lord,
I don't think it has been referred to in the earlier portions also. There is no.
there is no such rule requiring
No. Mr. Mitra referred to clause 5 pertaining to arbitration.
and pointed out that the invocation has been done in accordance with the rule 5 and rule 5.6. This has not been done. It is not in dispute that the application for appointment of arbitral tribunal was not as per the rules
This
of
may be
the.
the rule, as per Mr. Sinha.
Yes.
May be the rule.
Yes, no, it was not as per the rules of the National Stock Exchange. So the application for constitution is not as per those rules. However, my lord, if your lordship looks at the second last paragraph.
Yes, I get your point, Mr. Chaudhary, but
Section-
maybe the same rule loosely referred to.
Section 11
There is
rules
a chance
can't
of
be, can't be, my lord.
Maybe, but the court could take into cognizance, Mr. Chaudhary might have at least taken into cognizance that there are
Yes,
rules
yes.
for invocation.
My lord, my learned friend is right, my lord. Just before in the instant case, the paragraph before that, Mr. Mitra also submitted that it was mandatory to annex the arbitration clause of the original agreement or a certified copy thereof along with an application under section 11.
So that means also prescribe these kind of conditions.
No, that was on the invocation.
Yes,
Read this paragraph prior to that. It is not necessary for the court to go into the dispute with regard to whether stock exchange was obliged to interview whatever.
yes.
In its application, there could be no question of appointment of an arbitrator under section 11 unless the invocation was as per the arbitration clause.
That's a different matter.
But the rule 5 refers to the invocation.
There are two issues here. One is that as per the stock exchange rule, the invocation is
Either of you
improper.
may be right, Mr. Chaudhary, because there may be a distinction. This is speaking against what Mr. Sinha said, because it has been referred to in 2 earlier paragraphs. Mr. Mitra referred to clause 5 pertaining to arbitration
Yes,
and pointing out that invocation had to be in accordance with rule
with
5
rule 5 and rule
and in particular rule 5.
5.6.
That is the invocation. On the
Invocation.
invocation. Now
And-
that invocation, he might have argued that the invocation is bad because that is also reflected. Mr. Mitra also submitted it was mandatory to annex arbitration clause of the original agreement of a certified copy with an application. Now this is his submission. This is preceded by a paragraph not necessary for the there could be no question of appointment of an arbitrator under section 11 unless the invocation was as per the arbitration clause. The paragraph after that may be derived from that previous.
Yes,
Maybe, may not be. We'll
yes.
have to look into the mind of the court. We may ask the judge also. Yes, very good.
And
So
then
there's a
Miller,
doubt on
kindly,
this, we'll have to see.
kindly turn over to the last page, Miller.
So fodder for the Sunday.
Yes.
Yes. Last page, yes.
In Wellington Associates Limited versus Kirit Mehta, the Supreme Court held that before appointing an arbitrator, the Chief Justice and or his designate was required to satisfy himself on the existence of an arbitration agreement that made the appointment of an arbitrator mandatory. In this case, the court is satisfied that there is an arbitration agreement. Wellington Associates Limited Supra is not an authority for the proposition that a request for appointment of an arbitrator can never be entertained by the Chief Justice and or his designate unless the original arbitration agreement and or a certified copy thereof is furnished with the application. However, where the invocation is not in accordance with the procedure prescribed in terms of the agreement,
The may has become might in your favor. I mean, because it has been specifically held, here there is nothing in our rules to precede the invocation by something. This original.
now, Miller, the next judgment is this is a section 11 judgment directly on the point. The next judgment is a section 8 judgment.
Which is 3 and 4. It's 3 and 7.
Lord, page 3, second last paragraph. As to the technical ground urged by the plaintiffs that in the absence of the present application being accompanied by the original arbitration agreement or a duly certified copy thereof, it is incompetent. It only needs to be said that notwithstanding section 8(2) of the 1996 Act, the mandatory requirement would have to be met if there is a dispute as to the existence of the arbitration agreement. The plaint relating to the present suit admits the partnership deed of
Mr. Chaudhary,
1970.
subject to correction by Mr. Sinha, we may skip over probably to the last paragraph of the next page. So there, Justice Banerjee
Yes.
considers those judgments, and this is the crux of the finding. So let us see that first.
Yes, Miller.
There is a distinction.
There is a distinction between the role of the Chief Justice or his designate under section 11 of the 1996 Act and the role of a judicial authority receiving an application under section 8 of the Act. Once the dissimilarity is recognized, it may be better appreciated that the reliance on judicial pronouncements in section 11 of the 1996 Act may not necessarily be of telling impact in a section 8 scenario. Under section 11 of the 1996 Act, the party applying first asserts the existence of an arbitration agreement, but the mere assertion of such agreement would not entitle a party to apply thereunder if there is an agreed procedure for appointing the arbitrator or arbitrators. Where a party applying under section 11 of the 1996 Act asserts both an arbitration agreement and an agreed procedure for the appointment of the arbitral tribunal, the right to apply accrues upon the other party failing to act as required under that procedure, or upon the parties or the two appointed arbitrators failing to reach an agreement expected of them under that procedure, or upon a person, including an institution, failing to perform any function entrusted to him or it under that procedure. In other words, when a party applying under Section 11 of the 1996 Act asserts an arbitration agreement and an agreed procedure for the appointment of the arbitral tribunal thereunder, the party has to allege the breach of the agreed procedure for him to be entitled to invoke the provision. It is also of utmost significance to appreciate that an application under Section 11 of the 1996 Act would almost invariably precede any claim before any forum entitled to adjudicate upon the subsistence of the claim. Section 8 of the 1996 Act, on the other hand, entitles a party to arbitration agreement to apply before the judicial authority seized of an action with the plea that the action is covered by an arbitration agreement. In the one case, the claim is yet to be made. In the other, the claim has already been lodged. Though the broader tests to be applied may be the same in either case, there is a gulf of difference between the two. The Chief Justice or his designate paves the road for the claim to be launched before the arbitral forum on the acceptance of the existence of the arbitration agreement and the recognition of either there being no agreed procedure for the appointment, for the implementation thereof, or the breach of the agreed procedure.
This is more on 11.6. I mean 11.6 small a.
Yes. Then page 7, it is 6. Yes. Page 7, my lord, Atul Singh and Maestro engineers have been cited by the plaintiffs
Yes.
in support of the contention that this application is not maintainable in view of the original arbitration agreement or a duly certified copy thereof not being appended to the petition. The decision in Atul Singh on such aspect was upon recognizing that the existence and validity of the arbitration agreement was in serious dispute. In Maestro engineers, the view taken was that notwithstanding the subject matter of the suit being found to be covered by the arbitration agreement, if complicated questions of fact or law are involved, or where there is a serious allegation, or where a serious allegation of fraud is made, the civil court can refuse to refer the matter to arbitration.
But
The
Mr.
judgment-
Chaudhary, why is the findings on Section 11 not obituary in this matter?
It's a Section 8 matter. True. But my argument is, my lord, that in Section 8, if it is not mandatory, where it's admitted, Section 11 is a lesser test. Because the
Yes.
statute doesn't make
Obvious.
it mandatory.
Very
This was the first issue. Second issue, my lord, is more interesting. Mr. Sinha, my lord, argues that the agreement is void because it seeks assignment of tenancy rights. If it is a void agreement, in that case, it is impermissible for the court to act upon the void agreement and appoint a learned arbitrator. My response is this.
Section 9 filed by them.
Section 9 filed by us.
Well.
Filed by us. They have a prior suit. Now, my lord, firstly, assignment of tenancy. Firstly, scope of Section 11. Now, my lord, with 11.6 capital A, it's only confined to, my lord, the existence of the arbitration agreement. Whether it's invalid, valid, part of it is valid, part of it is invalid, is not a matter to be gone into now. It is a matter to be gone into in arbitration. Because if your lordship looks at this agreement, it is for transfer of management of a school with an assignment of, and one of the incidental effects, my lord, is assignment of the tenancy. Now, therefore, my lord, even for the sake of argument, my lord, if tenancy is not to be assigned, the rest of the agreement, my lord, remains capable of enforcement. This particular clause would not remain capable. So therefore, this is not a matter to be gone into now, and not an objection which can be recognized under section 11. Having regard to the scope of section 11(6)(a), section 11 by reason of 6(a). Second, please conceive of a situation where in the course of arbitration, I am in a position to have the consent of the landlord. This would be completely regular. It can be, given to me by assignment and I would become a regular tenant. There's no difficulty there. So this, per se today, if I have the consent of the landlord, can't be said to be totally void. And that's also a matter which will have to be decided. Thirdly, there's another, interesting line of judgments emanating, from the principle of pari delicto. In an eviction proceeding, this is not a defense which can be taken by the tenant. Landlord and tenant agree, or tenant and subtenant agree for subtenancy. In an eviction proceeding, this agreement cannot be used as a defense. But between the two parties who have unwittingly entered into this agreement and in an action for enforcement, having agreed with his eyes wide open to enter into an illegal transaction, it is not open to my learned friend to contend. For example, my lord, I decide to enter into an illegal agreement with Mr. Sinha in respect of something. The agreement is admittedly void under 23 of the Contract Act. He files for specific performance. I can't go and say that specific performance cannot be had because it's an illegal agreement. I am barred from doing so. I am an equal participant to this, unless the purpose is not for my personal benefit, it is for some other benefit. There are judgments on this. But again, my lord, perhaps, my lord, subject to correction, this is not a matter to be decided under 11(6)(a). I have got two judgments which I can cite. Now, এটা ছিল না লিস্টে। কোথায়? কি করেছো তুমি? We may have, ঠিক আছে তো, বসে নে। Yes. That there was a tenancy created on the basis of salami, which is prohibited under statute. In a later judicial proceeding, that was sought to be adjusted as part of the rent, whether it could be done or not, and what is the effect of pari delicto. May I read the first sentence? One cannot conceive of a greater judicial sin than the sin of treating the oppressor and the oppressed on a par, or in rewarding the oppressor or punishing the oppressed. We would be guilty of committing this sin if we upheld the view that the tenant who advances a loan to the landlord in order to secure the tenancy in violation of the prohibition to do so embodied in the statute for his benefit is in pari delicto, and the court will not assist the tenant in claiming adjustment of the loan amount against the landlord's claim for rent. Then paragraph 2 are the facts. 3, High Court had taken the view that since the loan advanced by the tenant was in violation of the prohibition contained in the Rent Act, the tenant was not entitled to claim adjustment of the loan amount against the rent which accrued subsequently. The tenant was therefore in arrears of rent and liable to be evicted. The view taken by the High Court is unsustainable inasmuch as the High Court has lost sight of the fact that the parties to the contract were unequal, the tenant was acting under compulsion, etc. Then, Millard, this is on unequal bargaining powers. I'm not, Millard, reading the whole paragraph. Page 381, middle of the paragraph. The law extended the protection but did not guarantee the roof. To deny access to justice to a tenant who is obliged to yield to the unlawful demands of the landlord in this scenario by invoking the doctrine of pari delicto is to add insult to injury and to negate the very purpose of the provision designed for its protection. The doctrine of pari delicto is not designed to reward the wrongdoer or to penalize the wronged by denying the victim of exploitation access to justice. The doctrine is attracted only when none of the parties is a victim of such exploitation and both parties have voluntarily and by their free will joined hands to flout the law for their mutual gain. Such being the position, the said doctrine embodying the rule that a party to a transaction prohibited by law cannot enforce his claim in a court of law is not attracted in a situation like the present. So, Millard, there are exceptions. Matter of evidence, I have to go and say and go and lead evidence to prove that he can't just come across today in a petition for enforcement. Law is, Millard, further made clear in AIR 1959 Supreme Court. That I won't go into facts, straight come to, it was paragraph 5 in the AIR, right? Yes, paragraph 11, Millard. 10 and 10 onwards. Millard, the principle is, Millard, that if it's pari delicto not to be 10, not to be really enforced or recognized, then the estate, Millard, lies where it falls. For example, Millard, if as a result of an agreement which is illegal, which can't be enforced at all, between me and Mr. Sinha, Millard, some money is, Millard, with Mr. Basu, then it remains with him, it's his, because the estate lies where it falls, nothing else can be enforced. So that was considered, and what was also considered is in an eviction proceeding, perhaps this cannot be taken as a defense, an illegal agreement. However, in enforcement proceedings, it can be. If I sue for specific performance, it's possible. Lord, please have a look at paragraph 10. It was contended that section 13(1)(e) had to be read separately and not in conjunction with section 15 of the Act. The section itself makes it quite clear that it is subject to the provision of section 15 and the two sections must therefore be read together. The appellant pleaded that under the agreement between him and the respondent, he was entitled to sublet the premises. Such an agreement, in our opinion, is void because of the provisions of section 15 of the Act and section 23 of the Contract Act, and enforcement of the agreement would produce the very result which the law seeks to guard against and to prevent, and by sustaining the plea of the appellant, that court would be enforcing an agreement which is prohibited and made illegal. The appellant relied on the maxim in pari delicto potior est such and such to support his plea that the respondent could not enforce his right under section 13(1)(e). But this maxim must not be understood as meaning that where a transaction is vitiated by illegality, the person left in possession of goods after its completion is always and of necessity entitled to keep them. Its true meaning is that where the circumstances are such that the court will refuse to assist either party, the consequence must in fact follow that the party in possession will not be disturbed. The respondent in the present case did not call upon the court, to enforce any agreement at all. When the instrument of lease was executed and possession given and subletting done, it received its full effect. No aid of the court was required to enforce it. The respondent's suit for ejectment was not brought for the enforcement of the agreement, which recognized subletting, but he asked the court to enforce the right of eviction which flows directly from an infraction of the provision of the Act and for which the Act provides a remedy. There is thus a manifest distinction between this case, where the plaintiff asked the court to afford him a remedy against one who, by contravening Section 15 of the Act, has made himself liable to eviction, and those cases where the court was called upon to assist the plaintiff in enforcing an agreement, the object of which was to do an illegal act. The respondent is only seeking to enforce his rights under the statute, and the appellant cannot be permitted to assert in a court of justice any right founded upon or growing out of an illegal transaction. So, my lord, in an enforcement proceeding, these questions have to be gone into. Whether this agreement contravenes any right in public, because I can't waive that. If not, if it's a private right, my lord, which is sought to be waived, if it's only for personal benefit, I can argue waiver and I can have it enforced because it's pari delicto. He can't be heard to say it's illegal. So all that I want to submit before your lordship now is that this is a very arguable question. And therefore, these arguments, my lord, would lie before the arbitrator. Perhaps in his section 16, perhaps in trial upon evidence. Third is, my lord, registration and impounding. SMST is the law on the subject today. 2010 5 SCC 40. Oh no, no. Oh sorry, 2011 14 SCC 66. Lord, paragraphs 22.5 and 22.6. For the purpose of registration, the arbitration agreement is delinked from the main agreement and it does not, my lord, prevent an arbitrator from being appointed. 22.5. To take advantage of a later sentence in the paragraph that if the agreement is void and unenforceable, then arbitrator would not be appointed. The respondent has made the earlier submission. However, my lord, that's an arguable matter and registration per se does not, my lord, prohibit. Secondly, I have clearly claimed specific performance. There's a pleading in my Section 9 application that this is my action for specific performance. So therefore, under the proviso to Section 49 of the Registration Act, there is an exception. Registration shall not stand, lack of registration shall not stand in the way of a specific performance claim. In a suit for specific performance, lack of registration is not an impediment. And Section 49 proviso to the Registration Act. And 2010 5 SCC 401 recognizes this principle. Paragraph 12. The main provision in Section 49 provides that any document which is required to be registered, if not registered, shall not affect any immovable property comprised therein, nor such document shall be received as evidence of any transaction affecting such property. The proviso, however, would show that an unregistered document affecting immovable property required by the 1908 Act or the Transfer of Property Act to be registered may be received as an evidence to a contract in a suit for specific performance or as, my lord, evidence of a collateral transaction. So, my lord, this is a suit for specific performance. Specific plea in my section 9 petition is, my lord, that it is for specific performance. I'll just indicate the even in the section 11 application, it's, my lord, available, but section 9, my lord, makes it very clear. Page 222 is my section 9 application.
Relevant portion, page 37.
Yes, 237, paragraph 29 of my section 9 petition. Petitioners are therefore entitled to specific performance.
No,
Of
show me
the-
from the invocation also.
From the invocation.
Something from the invocation.
What are it? 330
Third paragraph, third volume.
321, what third volume? Yes, my lord, on account of your failure to perform the terms and conditions of the MOU, we invoke. On the second page. Lastly, my lord, on the issue of limitation, in this case, my lord, it's a closed issue in my favor, because in my section 9 application and section 11 application, it's very clearly pleaded. Lord, if your lordship would be pleased to take my section 9 application. 9 টা দেখাও না। কালকে যেখানটা দেখ, yes,
Page 237.
237.
Paragraph 20. For the first time.
That same paragraph 29, it is relevant to state that the respondent's refusal is for the first time in June 2021, after which parties attempted to amicably resolve the matters. The concrete refusal is on 10th November 2021. So Article 54 of Schedule 1 would clearly apply. And further, my lord, there are other pleadings also which will show
So at least arguable.
beyond arguable, my
Arguable.
lord.
Right.
And this is not ex specie barred by limitation. And for that, my lord, if I may humbly rely upon a judgment which I unsuccessfully relied upon the other day. No, not this one. No, this is the Supreme Court judgment. Just paragraph 47. It is only in the very limited category of cases where there is not even the vestige of doubt that the claim is ex specie time barred, or that the dispute is non-arbitrable, that the court may decline to make the reference. However, if there is even the slightest doubt, the rule is to refer the disputes to arbitration. Otherwise, it would encroach upon what is essentially a matter to be determined by the tribunal. And my lord, please also see paragraphs 35 and 36. In fact, 35 to 37.2, which my lord records that that last amendment has not been notified yet, as on that day. That's very clear. And your lordship's judgment. ওই যেটা আগের দিন সাইড করেছিল ওটা আনা হয়নি।
If not necessary, don't cite, Mr. Chair.
I'm sorry, my lord, I didn't,
Thank God. Yes.
I forgot to give it to them.
Very good.
কোনটা
Yes.
আমরা থাকতে পারি কি?
In section 11 এ।
কোনটা?
নামটা ভুলে গেছি। I have
I have a lot of.
Sir, I have-
Help him if I.
Sarbopriyo written because he was the one who showed it
What
to.
was the point?
My lord, your lordship.
scheme,
on-
scheme.
No, on limitation.
Oh, acha, acha.
On limit, the one I cited the other day.
Yes.
But since I'm on, my lord, the judgment which I placed in that other matter,
Yes.
I will, my lord, tender an apology for, my lord, certain mischief Mr. Bhattacharya and I have colluded to do. If your lordship ever hears of anything and gets angry with us, Then, my lord, kindly accept our
The
joint.
Act, the statute, 96 Act.
No, in that other matter, my lord.
Regarding 96, oh, in the other matter.
In the other matter. If your lordship ever hears, before you get upset, also consider our joint apology, my lord, tendered now.
If I remember.
Yes. Well, the last submission, my lord, is that the prior suit is, my lord, and section 8.3 says that section 8 pending, you can proceed and make the arbitral award. So prior suit is not material at all.
That he's taking another point to the trust issue.
But the arbitration agreement, my lord, is between the parties here.
No.
My lord, kind
Between a partnership concern and a trust
Eight-
and the parties.
87,
Yes.
please have a look at the agreement.
Your lordship, the invocation notice has also been sent to the trust, but they have not made the parties.
Memorandum of understanding for takeover of Swarna School between Geeta Sundaram, Shobha Prakash, Roma Shankar,
Meenakshi Sundaram Educational
partners of school. First part. Second, my lord, Meenakshi Sundaram Educational Trust, Public Charitable Trust incorporated for the purpose of education and training of young boys, such and such. Party of the second part, represented by Geeta Sundaram, Shobha Prakash, Roma Shankaria, hereinafter collectively referred to as trustee of Sundaram Educational Trust. So, my lord, they have been represented by and they have been made, my lord, parties here. And petitioners are thereafter.
who are collectively referred to as trustees.
Yes. So they have been made parties.
In the capacity of trustees,
I just check whether
not individual.
They have not described.
paragraph 6, my lord, the respondents in their individual capacity and or as partners executed a deed of trust dated such and such in favor of themselves as trustees. Then,
Till that point, they were individuals.
yes, my lord.
Till that point, they were individuals.
No, and no, till that point of time and or as partners, then my lord, paragraph 9, my lord, last two lines, the respondents have executed the memorandum of understanding as trustees of Meenakshi such and such a trust and as partners of the partnership firm. So, my lord, paragraph 9 has, my lord, the pleading. And section 48 of the Trusts Act, my lord, in principle, even if it applies, all trustees have to be joined. My learned friend could have taken a point that they're not all the trustees, they're other trustees, etc. But that issue is not raised. And they were, my lord, representatives of the trust. So, my lord, and they have executed the agreement. So that's why, my lord, it's they may not have been arrayed as respondents.
Invocation was sent to the trust.
Yes.
Invocation notice, my lord, I'll just check.
Yes, yes.
D'accord. 321.
Fourth party.
Yes. Meenakshi Sundara Raman Educational Trust is the fourth party, 1, 2, and 3. I can't make 4 up respondent here.
Very good.
That's the. And there was one provision, my lord. I don't know whether it's in my favor or irrelevant or against. There was, in respect of a trust, my lord, there is a requirement under the Arbitration Act, or there's some provision. No, I'll quickly check up while my learned friend does.
You know the keywords, so check up.
Yes, yes, I
Check up
remember
during
seeing
the other
it
arbitration.
somewhere.
You were an arbitrator there in the
I
arbitration.
am appearing before Justice Ganguly in great difficulty.
You ought to argue.
Yes, I'm arguing. But that is much later, 11:30. That is much later.
Mr. Sinha will finish before that.
Yes, yes.
He'll finish placing the five-bench judgment before that.
Your Lordship, let me just go one by one the issues and I'll just finish it. Yes.
Yes.
And as I'm doing it, I'll deal with these judgments also, which have been tendered today. Your Lordship has a copy of that scheme. Your court officers, I think, told me that they have
was
not
saying.
been able to find. I've got another copy.
Oh, thank you so much. এটা এগুলোর সঙ্গে কোটেই রেখে দেবো এটা কপিটা এই কপিটা একটা কপি এখানে কোটেই রেখে দেবো এই ইলেকট্রিসিটি ম্যাটার এগুলোর সঙ্গে না একটা কপি রেখে দেবেন এখানে একটা জাস্ট এখানে রেখে দেবেন
একটা কোথায় জানিস?
Yes, thank you, Mr. Sinha. Yes. No, 1996, yes, right, this one. This is the only scheme probably which has been framed. This is the only scheme which has been framed.
Yes, when the 1996 Act came on to be,
Yes, yes.
there was a scheme made by every High Court and the Supreme Court for with respect to international arbitration in Supreme Court and the otherwise
Right,
all.
right.
Now, as my learned friend has already indicated, this is still in vogue because the 2019 thing has not come into force.
Yes.
Now, there are two things, Your Lordship. The judgments which have been shown, and I will show a particular judgment of the Shonji Banerjee also pertaining to Section 8. Now, if Your Lordship looks at Section 8 of the Arbitration and Conciliation Act, 8, where it talks about that it shall be filed with a certified copy or the original agreement itself, there is no negative tenet which is drawn with it.
Is it so? I mean, let us just.
Your Lordship will just have a look.
It's the other way around probably. Let us see
Your
two
Lordship.
once.
Yes, Your Lordship will see. It says shall not be entertained unless it is accompanied by, not
So shall not be entertained.
shall not
It's
be
negative language.
negative. But what I'm on is, Your Lordship, it does not provide, supposing, is there a discretion? It has been, some discretion has been read into, and now Your Lordships will see the proviso. All the judgments which have come in are prior to the proviso, because those judgments were with the fact that maybe I hold a copy of the agreement myself and I am not giving the other party a copy, and then the party cannot file a Section 8. So the proviso says no, in that case you will have to write and thereafter the consequences will follow accordingly.
Why is it not there?
Now, Your Lordship, what happens is with respect to the scheme, if Your Lordship has a look at the scheme, however, after indicating what has to be done and what are the,
এটা স্কিমটা এতেই আছে এটাও তো দিয়েছি you have given this hand this
I think that's my book, Your Lordship, that's
অরিজিন সাইড বইটা আমাদের আনানো হয়েছে এটা আমাদের
oh, then
নট এক্স্যাক্টলি
somebody,
ও তাহলে তো ঠিক আছে তাহলে আলাদা থ্যাংক ইউ
Your Lordship will see 3A says the original agreement or duly certified copy thereof has to be present. Thereafter, there is a specific provision, 7, leading to consequences,
yes yes
which is completely different. So the understanding that there is a lesser, as it's been argued, that the mandate under Section 11 is perhaps lesser, is perhaps not true. Under a conjoint reading of the regulations would perhaps show that the court has been given a specific directions of what has to be done. Under Rule 7, where if there is a technical default,
let us see how it has been couched
yes, Your Lordship will see, where the request made by any party under paragraph 3 of this scheme is not in accordance with the provisions of this scheme, the Chief Justice or the person or institution designated by him may reject it.
what reject it
May reject it.
Huh.
In the event, however, the rejection is by reason of a technical defect. Here's a technical defect. or an omission to furnish details as is required under paragraph 3, details and various subparagraphs there under the scheme, the party applying in terms of the scheme would at be liberty to file afresh upon obtaining, however, prior approval of the Chief Justice in the matter of initiation of fresh reference. So, Your Lordship, this is the same thing which happens in Section 8. Your Lordship will indicate a judgment here. Here also was a case where the arbitration agreement was never disputed. Here was also a case where the arbitration agreement was not disputed.
Yes.
Your Lordship will see two objections have been taken by the plaintiff to this application by the defendant number 1 under Section 8 of the Arbitration and Conciliation Act. The plaintiff says that the application is otherwise misconceived, but reminds the court that the application cannot be entertained in view of the first defendant having failed to comply with the mandatory requirement of Section 8 of the Act. For such purpose, the plaintiff relies on a judgment reported at 2009-1 Calcutta Law Journal, which at paragraph 10 holds that in view of the Supreme Court dictum, I think it was referring to the Atul Singh's judgment, Your Lordship, that the original or authenticated copy of the arbitration agreement had to be appended to the application under Section 8 of the 1996 Act. No leave can be granted for the applicant to use a supplementary affidavit to cure the defect. So, and Your Lordship thereafter says that since the previous judgment of the coordinate jurisdiction is binding, so and so is dismissed with liberty to the defendant to file afresh if the defendant is otherwise entitled. This defendant actually, Your Lordship, filed twice more, and each time it got dismissed for some technical default or the other. So
That matter.
Same matter, Your Lordship, same matter.
You are there.
Yes, Your
Oh,
Lordship.
yes.
This was the first time, Your Lordship, that
You are for the petitioner.
I was for the plaintiff.
That's
yes.
why you remember.
That's why I remember. That's why I remember. Interestingly, Your Lordship, I'll indicate that the next other judgments which have been relied upon by my friend, learned friend here.
Friend is fine. Friend is fine.
Your Lordship, may I just go by the judgments here? Now, the judgment which has been relied upon, which is on 2006 to Supreme Court 777. Your Lordship, that is
This is your, you filed a written notes of arguments today.
yes,
You are for the respondents.
yes, Your Lordship.
So these written notes will also be rejected. Brief notes of arguments on behalf of the petitioners. And I was being misled from the beginning. I was referring to this, and every time I was coming back
I think
to
why
Mr.
instead
Chaudhary and
I
trying to ascertain his name from the order sheet. And then I thought the order sheet was wrong. Then I realized that no, he was arguing entirely for the petitioner. Anyway,
He always feels he's for the petitioner.
you
I'm
cannot
very sorry.
forget that,
I
actually.
actually
That judgment of Justice Banerjee probably you cannot forget.
I
Take out of your mind. So that's why you're still for the
noticed my
petitioner.
stenographer in the night has done this. I'm sorry.
Anyway,
I'll correct it, Your Lordship.
yes.
Now the judgment which has been referred to, Your Lordship, with
2006.
regard to in 2006 to SCC 777, that was in relation to the CPC, provisions of CPC, and there was no negative connotations which were there in those provisions. Nothing was noticed in the Supreme Court judgment that there was a clear negative which was indicated. So that is factually distinguishable, Your Lordship. That perhaps is not a thing to which can be resorted to. Now the next one, Your Lordship, is the judgment of Justice Indira Banerjee. I think this is of it's 2009 SCC Online Calcutta 1003. Now this is in relation to a Section 11 application. Now two things I will indicate, Your Lordship, though I don't have them right now. Rule 5 with respect to these regulations which are referred to, National Stock Exchange Capital Market Segments Trading Regulations, they relate to arbitration. It's an extensive,
Yes, yes, absolutely.
they relate
That is
to
reflected from
arbitration
the order itself.
and how the arbitration will be proceeded with.
True.
There is an internal arbitration and thereafter, and now your lordship will look into,
That was a challenge to the invocation, as per this judgment also.
yes, your lordship. Now, your lordship will look into the conclusion, the second last paragraph. It is dependent on the what is being said is only with respect to that invocation. The rejection is also with respect to invocation, not
Yes, yes.
your lordship will see, however, where the invocation, second last paragraph.
True.
However, where the invocation is not in accordance with the procedure prescribed in terms of the agreement, there can be no question of appointment of an arbitrator in exercise of power under section 11 of the 19. This is not a precedent to indicate that whether Chief Justice's guidelines are mandatory or not. It is very important, your lordship, to indicate also that the Chief Justice's guidelines of 1996 do not even find a mention in this judgment. Where a regulation, mandatory regulation, doesn't even find. It is possible that there might be an interpretation which says that no, it is directory, it may be not mandatory.
What did the court mean according to you, Mr. Sinha, in the penultimate page,
yes, your lordship,
the penultimate paragraph?
procedure, rules of procedure?
Yes, what is that then?
Your lordship,
Beats you.
Beats me, your lordship, really beats me.
Unless it is a scheme.
Your lordship, it cannot be.
Whether you call it a flower or a scheme or a rose or whatever.
Really cannot be implied where some other regulation extensively how.
Only one other rules of procedure of our court regarding.
It's a question of question of procedure.
Section 11. This is section 11.
Section 11.
Because the requirement under the rules of procedure to file an application under section 11 can only be of the High Court.
Your lordship, may I submit this? I am not aware of this. The entirety of this regulation of the trade.
Cannot be, no. Neither am I.
But I don't think, your lordship, otherwise also here there is no discussion with regard to these rules and regulations. The provision does not say it can be waived. The provision is very clear in its grammatical meaning. As your lordship was indicating about section 8.
What is the grammatical meaning of may?
May is a discretion. It can be waived. It says that
it's a discretion.
Maybe no, your lordship.
It's not a discretion.
When it is admitted, the question is when it is admitted.
The may in the scheme.
May in the scheme, but it says waived when admitted. It doesn't say that it is directory otherwise. This provision, if your lordship sees the judgment, it doesn't say it is directory anyway.
Not the judgment. Let us see the scheme itself. 7.
Yeah, it says may reject. It says it may reject. May reject. My argument is has to be read as a mandatory provision. May shall be read as a shall because of the entire thing with regard to section 8 and section 11 being the same. And I will show your lordship when I'm dealing.
Should be read as a shall in the light of the Justice Banerjee's judgment, Justice Indira Banerjee's judgment. Do you say that?
No. Not because of that.
Because we have that judgment with us. We have to read it in that light. Because it refers to some rules of procedure. No other rules are shown before court. Anyway, let us not dwell on that. That's the weakest link.
Yeah,
yes.
And the last one, your lordship, again, in the Hindu Kochar judgment, which was indicated by Justice Sanjeev Banerjee's judgment of 2011, two things are not noticed. One, again, the Chief Justice's guidelines with respect to section 11, as your lordship indicated, is not a matter with respect to section 11. Perhaps that's why no discussion on that. It was never noticed. And further, your lordship, Justice Banerjee did not even notice his own judgment, which I have just shown. This is an older judgment. That it was a binding provision and couldn't go anywhere other than that. There also it was an admitted.
Is the earlier judgment a ratio on that?
Your lordship.
Was the proposition raised, argued and discussed?
Your lordship.
Was any proposition laid down? Justice Banerjee's sentence was one line. It was one sentence.
Is that I am bound because of an earlier High Court judgment.
Justice Banerjee felt so.
Yes,
what is the ratio in that judgment? As compared to this judgment of Justice Banerjee?
Your lordship.
Unless you say this is obiter, obviously that is there.
No, other than the fact it is obiter, I am also indicating, even with respect to section 8, once a judgment has been given, that judgment binds the court, unless it specifically says why that was a wrong
All right.
something which was wrong. And
Judicial propriety and decorum also.
one
yes.
thing, and also Justice Banerjee, your lordship will see in that other judgment which I have indicated, mentions a judgment of the Calcutta High Court itself, which is binding on him, and that is why it is there.
Yes.
That judgment also doesn't find any reference in this particular judgment.
All right.
So by that clear thing, your lordship, this perhaps is not a binding precedent on that and cannot be taken up. Bristol Airways, all those judgments of 1943 Appeal Court. Now, leaving this aside, technical defects, and also indicated, and one more technical thing which I was indicating was that your lordship will see the invocation letter. The invocation letter was given also to the Meenakshi Trust, which is the second party in the memorandum of understanding. The arbitration is sought not here only against the persona of the three sisters. It is sought against the rights accrued, as they say,
It is sought on the basis of one agreement, a particular agreement, which has
Agreement.
been referred to.
one agreement which
Where
has
the
been
trust
referred-
is a party.
Trust is a party, partnership is a party. The partners of the partnership firm, section 69, otherwise unregistered partnership. That's why the partners have been made party. I cannot.
That provision is very difficult, Mr. Sinha. Please look at the watch, clock. That is the provision which is against you. Add an A to that.
Your lordship, I will say that it is not. This I'm
It is not.
covered. I'm
Very-
covered this time.
Yes, anyway.
Yes. Now,
So you say, what is the technical flaw then?
Because-
In the invocation, it was the trust to whom it was sent, one of the
Yes.
addressees.
yes,
Yes,
but that trust has not been made a party in the
Yeah.
particular proceeding.
definitely.
Now,
Yes.
what is being said is, and your lordship also has seen when my learned friend was indicating the paragraphs, there is no assertion that the three persons are being proceeded against as trustees. It's not. That is not what is being said. There's no description of it. Now, the law is under Order 31 of CPC, that when something is going against a trust, also the trustees have to be made a party. It does not mean that the trustees will be made a party and the trust will not be made a party. Because I've made the trustees a party, I will not make the trust a party.
What is the meaning of that provision? What is the meaning of Order 31, that provision?
Your lordship,
Trustees they have to be made a party.
they have to be made a party.
And
Trustees-
trust may not be.
No, your lordship, it doesn't talk about trust at all.
Why does it exclude trust?
Because the mischief which was being covered under Order 31
Acha.
was that in a trust earlier days, and specifically Shabayats and all those situations,
Hmm.
what would happen is
Let us look into that provision, Order 31. Acha,
your lordship
excuse
will see. Thirty-one two. 31(2) is the provision
Hmm.
where there are several trustees, executors or administrators. They shall all be made parties to a suit against one or more of them.
This is on a different note. I mean, what you are saying is correct.
Yes. So I am just only saying that this is the provision which can save them.
What is, please read out one also.
Yes, your lordship.
I mean, rule one.
Yes, I'm just coming. In all suits concerning property vested in a trustee, executor or administrator, where the contention is between the persons, because beneficially interested in such property and a third person, the trustee, executor or administrator shall represent the person so interested, and it shall not ordinarily be necessary to make them parties to the suit, but the court may.
So the trust has to be. Your argument.
Yes,
This is
the
in your
trust-
favor in a
yes.
sense.
Trust has to be.
Very good.
The trust has to be made a party.
Hmm.
And your lordship now. So these are only the technical aspects, your lordship.
Trust must be a party in what?
Your
The
lordship.
suit,
In
litigation.
any proceeding, it is here also order is being sought.
This does not provide for any proceeding. Mr. Sinha, there's a difference because 141 may not apply to everything.
Your Lordship,
In any proceeding, whatever is, because some judgments are there, some line of judgments in an interlocutory proceeding, if there's an injunction passed, so it's not under Order 39.
Your Lordship,
Executive Justice she may be, but not Order
Your
39.
Lordship, I am quoting the best case scenario which can be pleaded.
That arbitration proceeding has to have the trust as a party. Invocation trust was a party.
Yes.
So
And-
this section 11 is in between. I mean, I'm making out the worst case against you so that you can.
Yes, absolutely.
Yes.
I am quoting on the other hand 31(2) as their best case, which they can say that
No,
we have-
that's not their best case. You may say 31(1) is a best case, or you may also say 31(1) read with 2 in conjunction may portray that trust has to be made a party, but the trustees may or may not be.
But your Lordship,
One is very specific for you,
yes,
but they cannot rely on 2 as such,
very
if
well.
you say so.
Yes, your Lordship, then
Subject to what
then,
he
then,
says.
then your Lordship, I'm at a much better footing
Hmm.
because any party, any person which is a party to the arbitration agreement against whom a relief is being sought.
Is this a suit?
No,
Concern?
I'm not going into 31 because your Lordship doesn't want to go into 31. I'm just
No, I want to go into everything
I want
and
to go
distinguish
into
everything, whichever, either of the two.
Your Lordship,
That's
I
an
want to-
addiction now.
Your, Your Lordship, now, Your Lordship, I just want to go into Section 11 of the Arbitration Act.
Yes, exactly.
Section 11 Arbitration Act. A invocation notice has been given
Yes.
to 4 persons, 4 parties. Against 3, this application has been made. Simpliciter, it is bad in law because they are trying a specific enforcement of rights, accrued so-called rights, which they still say is subsisting under 8th June 2012 memorandum of understanding, in which the trust is a party. Without that party being made a party in this proceeding, this application fails.
Very good.
This is my technical, Your Lordship, this is the technical point which I was indicating. Now, Your Lordship, I'll go back to my main arguments.
So let us go backwards then according to your point. So we have started from trust, like in a circus previously. Trapeze first, in the next show, it will be the.
No, I'll just say, tell you the now, Your Lordship.
Lion first or trapeze first?
Now, Your Lordship will.
He meant something else, Mr. Sinha.
I know.
He said he as opposed to trapeze, and you are arguing.
Your Lordship will now come to.
May I have my
Yes,
last
yes.
leave? We are really grateful that your lordship came today.
Thank you.
And
Thanks
at
to
10
both of
o'clock.
you, actually.
No, I think it is a new thing to do.
I don't
Maybe
think so.
We shall ask.
It's a
for that.
one-off instance, probably.
Yes, but we've done it.
Anyway, this should
It's-
be there.
It's a great practice.
You understand when you go outside Calcutta
Yes.
why these are necessary.
No, why?
Either you go to litigate or to argue a matter, or in judges' conferences, this becomes mated. These things
Yes,
become.
I've
these
seen
messages should go.
Bombay High Court sits on Saturday. Some learned
go.
judges.
Yes.
So we are also capable. We are
And
no
we're in
less-
the front line in many matters, Mr. Chaudhary, which are not projected properly. Yes. In technology also, in certain cases. Anyway, leave that.
I'm-
Yes. Thank you.
Back, Your Lordship, what happened, I had a pleasure of missing a flight once because I was appearing before Justice, I'm retired now, the Justice Kathawala's court.
Justice Katha,
And I had no idea, and that it is also a
you
section.
missed nothing.
section Justice Kathawala's court.
You
I was
missed the
appearing
flight, took the next flight, missed nothing.
Lord,
At 9:30 is the flight.
Yes.
I was at 9:30 arguing in court.
I have also appeared before his lordship.
Yes, you said that on one other occasion. I mean.
Yes.
You had
I have little experience in Bombay High Court. I've been twice or thrice. Lord, my lawyer friend in Calcutta took me saying that this is a matter. The people are saying that better that you bring somebody from outside. Nobody wants to oppose. So I went and it was nothing difficult. Then I have
Moved at which hour?
no, but to
It was
oppose.
taken up for hearing at what hour?
No, during court hours. It wasn't
Court
a
hours
6
is all right. I mean,
Yes,
at 9:30 it may become easier.
and his lordship was a bit angry on my client and said the client was also present in contempt and said that I will send them to jail. I said, yes, definitely. It is your
Your
lordship.
usual style, Mr. Chaudhary, we know that. We know that.
Definitely.
The more suave the argument, the worst is the case of the client. That by now we know. Mr.
But it wasn't, we were used
Don't be
to,
so suave in this case.
we were used to code 16. It was not new.
There was no option.
We were
There was
used,
no other option.
it wasn't difficult. Grateful.
Yes, Mr. Sinha.
This is a packed courtroom at 9:30. So the packed courtroom went on till
Oh, sir.
packed courtroom went that day. Apparently, the court went on till 3:30 because the day before vacation, summer vacations, 3:30 in the morning. And then he took the logistics took special permission to sit by 10 next morning to take because all the admiralty matters otherwise could get affected.
He had his quarters in court.
No, but he did, and it came.
Must not have been married. I mean, I don't know. I have no idea.
Yes. Your Lordship, then, as Your Lordship indicated, I'll keep it to the trust first and deal with the matters relating to the trust and then move on. This is the
It means you have to do everything within one.
Yes, now, just.
Yes.
Your Lordship, this is the point I was indicating, which is not there in my notes. I will add this point which I'm going to place now. Your Lordship, if Your Lordship comes to page 34 of their application.
Yes.
Your Lordship, this is the deed of trust. Deed of trust. Now, Your Lordship, in this, the description of the trust is given. Your Lordship will come to page 40. Whereas, does Your Lordship come? Page
Yes.
40.
Yes.
Whereas the settlers hereto are desirous of establishing a public charitable trust. It's not a private trust, public charitable trust for the purposes of educating and training young boys and girls in education pursuits, additionally, etc. Now, Your Lordship, the law under the Charitable Trust Act of 1920, though it does not provide so, the judgments of this court here, relying on a 1963 Supreme Court and all whatever,
Principles will.
principles of the Trust Act will apply. And in that, if there is any kind of alienation of any rights with regard to immovable properties, then the permission of a court, the principal court, will be required. It cannot be done by private treaty.
In regard to a private trust also.
This is a public charitable trust.
Oh, this is the public.
This is a public charitable trust.
Very good.
I'm not even into a private trust. This is a that is why I indicated it's a public charitable trust.
Yes, yes, right.
So now, Your Lordship, I'll just give the judgments on this point. Your Lordship, the first judgment I will rely upon is AIR 1975, Calcutta 67. I'm going to copy the chat. Your Lordship, this judgment, short judgment, Your Lordship will only look into paragraphs 4 and 5. Next page. The first point taken by the applicant in the instant application is that since the trust is a religious and charitable trust, the said application by the trustees in which the order was made on April 11, 1973, under Section 34 of the Indian Trust Act was not maintainable, and that this court had no jurisdiction to pass an order under the same. the provisions of Section 34 of the Indian Trust Act are similar to those of Section 7 of the Charitable and Religious Trust Act. The impugned order was made on 11th April 1973 on the application, wherein the cause title mention was made of Section 34 of the Indian Trust Act. Apart from the said mention of Section 34, there was nothing to show that the application was not made under Section 7 of the Charitable and Religious Trust Act. This is on form. The application, in effect, was made by the trustee seeking a direction from this court to grant lease of the trust property, number 48, Sir Hariram Goenka Street, Calcutta. As a matter of fact, in the Charitable and Religious Trust Act, there are no provisions similar to those contained in the latter portion of Section 36 of the Indian Trust Act. Therefore, in respect of the provisions in the Trust Act, the provisions in the Trust Act should be followed. In a case reported in AIR 1941, Allahabad 387, the bench decision presided over by the Chief Justice Iqbal Ahmed has been that though the Indian Trust Act does not apply to public or private religious charitable endowments, but nevertheless, the principle underlying the section served as a useful guide. Now, Your Lordship, this judgment was thereafter relied upon by the Calcutta High Court again in 2010. Your Lordship, this is report Mohanlal Seal versus Kanak Lal Seal. I think my learned friend was appearing in that at one point of time. Not Seal. This is reported in 2010 3 CHN 597. Your Lordship, unfortunately, the SCC copy, I see there are no paragraph numbers. I have to take Your Lordship through indications.
Give me the page number.
Page number 2, Your Lordship will come to page 2, last 2 paragraphs.
Yes.
Last 2 paragraphs. Mr. Sen argued that Section 36 of the Indian Trust Act, which is it was necessary to obtain permission of the principal civil court of original jurisdiction to execute a long-term lease. In this case, it was 21 years. Here, they have described themselves, as I indicated, Your Lordship, as purchasers. They are taking over. Lock, stock, and barrel, they are taking over for eternity. Not even 21 years otherwise. There's an alienation of my tenancy rights per se. Now, Your Lordship will see. Mr. Sen, next paragraph, argued that even though the trust was a charitable trust to which the Indian Trust Act did not apply, all the principles embodied in the Indian Trust Act would apply. In support of his submission, Mr. Sen cited the judgment of this court, the one which I have just relied upon, 95, and the judgment of Somgiri Ram, that was Allahabad, that is the one which was reported there, which followed and approved. In support of his contention, the principles of the Indian Trust Act would apply to private, public, religious, and charitable endowments. Mr. Sen also cited the Supreme Court judgment in 1963. But Your Lordship, then Your Lordship will come to page 4. I'll trouble Your Lordship with 3-4 more paragraphs.
This is it. Yes.
It is therefore expedient. Your Lordship, this is Lordship takes
Got
the
it.
second paragraph from bottom.
Yes. Yes. Got it.
Yes.
Expedient.
It is therefore expedient that all transfers of property held by religious or charitable trusts should be opened by issuance of public notices and or advertisement. The transfer should be given sufficient publicity to fetch the best prices. This has apparently not been done. So it is on facts. Then in Dhanalal Karnawat, a single judge, that's a 1975 judge, overruled the objection that an application under Section 34 of the Indian Trust Act was not maintainable in respect of a charitable trust and held, and this is a paragraph which I have already indicated, Your Lordship. Then it comes to next paragraph. The judgment in Dhanalal Karnawat is binding on this bench of coordinate strength. Prima facie, the application 80 of 2007 is maintainable. The plaintiffs have been able to make out a good prima facie case for the suit. The principles of Section 34 to 36 of the Indian Trust Act and 1882 are attracted. Then it quotes the same 1963 judgment, and thereafter, Your Lordship, Your Lord, comes to fourth paragraph from bottom. This court is also of the view. Same page, Your Lordship, same page.
Yes.
This court is also of the view that a long-term lease exceeding 21 years requires the sanction of court as provided under Section 26 of the Indian Trust Act. And in any case, that has to be the best rent. So, Your Lordship, my submission was that, relying upon these two judgments, that with regard, there are two parties here. There are two parties. One, because the school, how it was divided, interestingly, is till class 4 is run by the partnership. From 5 onwards, it is run by the charitable trust. So that is why the two parties have been brought in. Now, with regard to the charitable trust and their giving up their interest over the tenancy of the rights over the property, that, Your Lordship, requires sanction of the court. I have shown two things. Your Lordship, I have already argued and I will show, I have already showed Section 5(1)(h) of, 5(6), subsection 6 of the West Bengal Premises Tenancy Act, which was attracted because under the KMC, I have indicated that, Your Lordship, under the KMC, it was the rent was below 10,000. So, Your Lordship, West Bengal Premises Tenancy Act was applicable. So under 5(6), without the previous sanction, it could not have been transferred. Now, my learned friend has made an argument with regard to that part, 5(6), not based on a judgment, but otherwise made an argument that it is an arguable case, and on the ground that while the arbitration is going on, the sanction or permission of the landlord may be obtained. That is because the landlord only introduced me to these people. The entire purpose was to make me fall into this. This is a misrepresentation angle, which I said, voidable, I'm not going into, and that is perhaps they are so sure. But otherwise, however, Section 5 says, no 5(6) says, no tenant shall. Doesn't say without the consent. It says without the previous consent. The word is without the previous consent in writing of the landlord, transfer or assign his right in the tenancy on any part thereof. Admittedly, there is no previous consent. Nothing is reflected in the MOU. Nothing has been produced otherwise. No document has been, contemporaneous document has been produced. No argument has also not been made that there was a previous consent which was there. So what happens is 5(6), it falls foul of 5(6). It also falls foul of Section 26, which requires the previous sanction of the court with regard to public charitable trusts. So, on both counts, this agreement is void. And I've shown Your Lordship the construction of this MOU. The word management and otherwise is there. The only thing is that is broadly written every place is transfer of tenancy rights. It is not transfer or taking over, somebody's taking over management control. It's mainly about being a purchaser of a charitable trust. Anyway is not possible. Otherwise also is not possible. There's no question of buying out a charitable trust. Automatic sanction of the court will be required under Section 26. So that is why. Now the next, however, the question which comes in is with regard to another argument which has been made, whereby my learned friend has relied upon these judgments that you cannot take advantage of, basically saying that you cannot take advantage of your own wrong. At the end of the day, that what it transpires to. Your Lordship, this is the judgment in 1986, 2 SCC 378. Your Lordship,
Yes.
This has been relied upon.
Hmm.
And there is a statutory answer and there is a legal within the judgments itself. I'll show. Your Lordship, this particular judgment, however, I don't think has any kind of relevance, but with all due respect, because this does not refer to a particular contract under which it has happened. It refers to a salami amount which had to be given. Otherwise, it did not give, a loan was not given, he would not be entered, will not be allowed in. So the question of oppressor otherwise does not come in here. Let's take, my learned friend referred to the paragraph number 1, which talked about, and I'm reading it out again. One cannot conceive of a greater judicial sin, and I will use it to my advantage. One cannot conceive of a greater judicial sin than the sin of treating the oppressor and the oppressed on a par. 75-year-old, 80-year-old woman being told that which they have been running a charitable trust to for education of children at 30 rupees or 25 rupees a month. They have been told that they will be run. They have been taken for a ride, and they are producing a judgment which says we are the oppressor, which they are the oppressed. Now, Your Lordship, the next judgment. I'm slightly more curious about the next judgment which was placed. Your Lordship, now, Your Lordship, this judgment, which was, I think, cited here, is of 1959 Supreme Court, 689.
Yes.
Now, in this judgment, it's a very interesting thing is, the argument which has been run is that it is an arguable case. Because it's an arguable case, it should be relegated to the arbitrator. Because whether it is void or otherwise, it is not void. Here it was held, it was not void, because it was not a matter for enforcement. Because it was not a matter for enforcement. It said that if you are, paragraph 10, I am also relying upon paragraph 10. Last portion of paragraph 10 of this judgment. It says, such an agreement, in our opinion, is void because of the provisions of section 15 of the Act and section 23 of the Contract Act. And the enforcement of the agreement would produce the very result which the law seeks to guard against and to prevent, and by sustaining the plea of the appellant, the court would be enforcing an agreement which is prohibited and made illegal. Your Lordship, the invocation notice is for what? Specific performance of the agreement, enforcement of the provisions of the agreement. This case is not. On the other hand, this Supreme Court judgment, I'm thankful to my friend, is on the point that if there is somebody seeking a specific enforcement, and that is specific performance of a contract, if there's, it is a void thing, and then you cannot take the defense that no, they have received some kind of remuneration or they have received some kind of benefit. Then that this is not the case. This runs completely counter to the argument which is being made.
But void on what ground do you say?
Your Lordship, void on 2 grounds I've already indicated.
Yes.
One under the West Bengal Premises Tenancy Act.
So that is not on specific performance.
No, they are seeking specific performance.
Apparently, Mr. Chaudhary was arguing there are 2 components. One is assignment, tenancy, another is management.
Yes. May I just, I'll come to that. I'll come.
Probably sought to distinguish that. So
Yes. I'll come to
yes,
that part also.
we'll have to deal with that also.
Can the management, again, I'll join issue there, management of a trust be bought? They are described themselves as purchasers. They are buying the management. Can it be done without the sanction of the court? Charitable trust, it cannot be done.
That bar comes.
That bar comes in. If this bar is not sufficient, that bar comes in.
Very.
Your Lordship, now they are seeking specific enforcement. So this is not a question. This Supreme Court judgment is in our favor, which says that it is a void contract and you cannot have any realm under that. Now, also, as I said, Your Lordship, there is a answer in the statute. Your lordship will come to, because it's my duty to show that. What interpretation comes in after that is a different thing, but it's my duty to show that. Your lordship will come to section 65, and it is noted in the new judgment which has come in. They have noted this. Section 65 of the Contract Act. Your lordship has a copy of the Contract Act.
আচ্ছা আচ্ছা আছে আনানো হয়েছে
Your lordship.
Yes.
Obligation of person who has received advantage under void agreement or contract that becomes void. We say it's a void agreement. Their argument is that you have received some advantage, so arbitration should proceed. When an agreement, your lordship is small, when an agreement is discovered to be void, it is both parties have come in, it's discovered to be void, or when a contract becomes void, any person, that means voidable contract, somebody says, any person who has received any advantage under such agreement or contract is bound to restore it or to make compensation for it to the person for whom he received it. Now, your lordship, the agreement is void. The agreement is void. Is it a case that they don't have a remedy? They have a remedy. File a civil suit, if you have a remedy, you have a remedy under section 65. But an agreement which is void per se, and on the face of because of applicable law, there is no question of being reference to arbitration. Now, your lordship, I'll come to the paragraphs of these main judgments which I'll refer to. Your lordship will just give me a... Okay, may I, before dealing with the main judgments on this point, may I just deal with, in short, the section 8 and 11 point? The section 8 and 11, I've just...
Five judgments will be your last point, probably.
Last point.
Yes, I think that will be better.
Yes. So other points, I'm just...
Shorter points first.
Yeah, shorter points, I'll
Right,
just finish.
Like a pawn shop, sort of. I mean, the loose cigarettes are sold
So quickly, loose
quickly,
cigarettes are sold.
yes. But the pawns are
Path
set
is
and
made
all.
in- Now, your lordship, I will refer to, and I thank my junior friend here. It was all his research.
Obviously,
It's all his research.
very evident.
Very evident, your lordship. Have your
Few
lordship?
people acknowledge that, but thank you for acknowledging.
No, your lordship, it's absolutely him.
Yes.
Rohit Mukherjee.
No,
he's
need
just
not stand up.
He has joined my senior chamber, so he has been assisting me helpfully in matters.
Very good, yes.
Yes, your lordship, two judgments. I'm doing a copy.
So you have referred to the judgments in your notes.
One judgment I have. One
Then
judgment.
you have to, the notes
I will,
have to
I
be
will, I will,
comprehensive,
I
yes.
will, I will find, because 2-3 I found it in the morning because I was responding to Mr. Jishni Chaudhary's notes. I'll make it a comprehensive and give it. I'll just give it because your lordship
Then I'll
wanted
take their notes also on a subsequent date.
Yes, yes.
You give a copy of this.
Yes,
with
I'll give a
comprehensive
copy to
thing,
them also.
so that they can file a comprehensive.
Yes, absolutely. I'll give them a copy. Your lordship, this is the first judgment on this point. This is a judgment of Justice Vinod Kumar Gupta, 1999, SCC, online, Calcutta, 615. Your lordship, I will just not trouble you too much because paragraph 6, next page, it says, insofar as an application under section 11 of the Act is concerned, this is also held not maintainable in this court for the simple reason that the petitioner before me is under an obligation to approach the civil court under section 8 of the Act and make an application for obtaining an order of reference of the parties to arbitration in terms of that section, depending on the merits. If a civil suit has been filed by a party against another in a civil court, and if one of the parties in that civil court claims that with respect to the subject matter of the suit, an arbitration agreement exists between the parties, and the civil suit not being maintainable, the parties have to go to arbitration. The remedy of such party lies not in invoking section 11 of the Act, but in approaching the aforesaid civil court seized of the aforesaid civil suit by filing an application under section 8 of the Act.
Is it without taking note of 8.3?
Your Lordship, 8.3, I don't see they have taken note of 8.3. I stand by that. That's why I said I just not trouble you too much.
No.
I have
No trouble. Yes.
Your Lordship, what happens subsequently to this, I'll tell you. There is another judgment following this order. Another matter gets dismissed. A division bench appeal, somehow the division bench says that the latest patent appeal is applicable, and that's why it takes cognizance of that. But now, Your Lordship, that judgment perhaps is completely not right law, because the Supreme Court and everybody has held from section 11, there can be a 136, article 136 appeal, special leave petition. There is no question of a latest patent appeal or otherwise. In that
non-maintainable appeal, this ratio was held, which helped you.
No. In the non-maintainable appeal, it was against me. It said that no arbitral tribunal can be constituted. It said so in the division bench.
So don't cite that then.
I'm not citing that. I'm not citing
Passed in an appeal which is not maintainable.
maintainable. That's why, Your Lordship, I'm submitting something else. This I've given in the notes also. This perhaps is very interesting. This, Your Lordship, would be my argument if Your Lordship is otherwise not convinced of any other argument which I have raised till date.
That's it.
This is the last. Your Lordship, this is a judgment. Your Lordship, this is a judgment. Here, everything has been considered. 2010, 1 CHN 658, Justice Mukherjee's judgment. Calcutta South City Projects versus Jugal Kishore. Your Lordship, in this, what happened? Your Lordship, I think I gave you my marked copy.
No,
I think.
Oh, yes.
Yes, I'm sorry.
Thank you.
I'll give it back. Your Lordship. I'm sorry. When I opened it, I suddenly found the paragraph markings again. Your Lordship will look into paragraphs. I'll start 3-4 paragraphs.
Yes.
Paragraphs 12 first.
Yes.
2010,
The section.
11, 1 CHN 658. Your Lordship, a decision which is of much importance and gave rise to considerable indecision in my mind before deciding this case is Shukanya, Your Lordship, Shukanya Holdings judgment. In that case, the subject matter was a partnership agreement which had an arbitration clause. In a 2000 suit was filed in the Bombay High Court for dissolution of the partnership firm, accounts, and for cancellation of the conveyance deed in favor, so and so. This is the premise of what this judgment is. Your Lordship, I may also tell you that in this particular reference also, there are parts of the civil suit which are there, which cannot be decided by the arbitrator, because we are asking for cancellation of power of attorneys. Power of attorneys is in right in rem, something which is happening in rem. That I will show the Vidya Dolia judgment is clear on that. It's a right in rem. It cannot be decided by the arbitrator at all. So there, if arbitral reference is allowed, there will be a bifurcation. There would be a complete bifurcation on the same facts. Now, Your Lordship, I will not trouble you with the rest of the things. What happened is this matter was, the court found in this particular matter was that the facts and the things to be decided are the same. Facts and the things are to be the same. Now, Your Lordship, I'll just invite your attention to the last page, the last paragraphs in the last page, only on the conclusions of what has been drawn. Because I said this is if Your Lordship finds that otherwise that arbitration reference should be allowed, then perhaps this is the thing that has to be done. Your Lordship will see. Now, in this case, paragraph 18, from paragraph 18, now in this case, if a result of the petitioner not filing a section 8 application in the entire subject matter of the proposed arbitration reference could be tried by the court, then under the above principle, there would be no dispute to refer to arbitration in a section 11 application. But in this case, there is a subsisting dispute not covered by the subject matter of the suit, as I have already held. Further, the Supreme Court in Shukanya Holdings Supra has specifically approved the observation of the Bombay High Court that two forums are not to be allowed to proceed simultaneously with the same or substantially the same matter, which your lordship I indicated. If today the section 8 is refused and section 11 is allowed, that will be exactly what will happen. Now, I think, your lordship, the conclusion, I think that in this kind of a situation, the court should apply the principles of section 10 of the Code of Civil Procedure. The Alipur suit is first in point of time, which is also the same. Alipur suit. My suit is also in Alipur suit.
That is also a common point.
Common point. The arbitral proceedings were commenced later. The notice is 2020. Success of the petitioner in the Alipur suit would be conditional for it being successful in this arbitration. Only if the case for specific performance of the agreement to lease fails can the suit for rescission possibly succeed in now. The arbitrator may be appointed, pleadings may be exchanged, discovery of documents may be made in the arbitration reference, but further hearing should be deferred till the outcome of the Alipur suit. If two suits had been filed instead of one suit and one arbitral proceedings, the court could have directed their analogous hearing. But since one is before a civil court and one is before an arbitral proceeding, the arbitral proceeding has to be stayed till the disposal of the suit. Therefore, in my opinion, the arbitration should start only upon conclusion of the Alipur suit. This High Court has the power of superintendence over superintendent courts. Therefore, in exercise, I direct the complete the adjudication of suit within so and so time.
Mr. Sinha, do you have a copy of your plaint?
It is annexed.
Very
It is annexed.
Fair.
Page 291.
I'll leave it.
Yes. Page 291, it is annexed, your lordship. Though they have not annexed the annexures,
Need
but
not.
the
Prayer, prayer,
the
relief,
main
yes.
bodies they have been
Right. Pleadings and relief basically.
yes, they are there. Page 298, the reliefs are there. It is there. So now this is the judgment which your lordship, I was relying upon. That in my reading and reading of the Supreme Court judgments, which were not adhered to by the courts when they were deciding on relatives between section 8 and section 11. Now, your lordship will now, I'll invite your attention later on also, but as of now, only to finish this point and then move on to the main judgments. Your lordship. Your lordship, this is the Vidya Drolia judgment. I have a copy.
Give me the paragraphs,
I will give the paragraphs. Also.
the ones on which you want to rely.
Yes. Now, I will rely on different paragraphs. Your lordship will keep the book for different aspects of my
Ah, very,
argument.
very.
So at this moment, your lordship, I'll invite your attention. Your lordship will just give me a moment. Your lordship will come to page 116.
Yes.
Your lordship comes to page 116. And your lordship will absolutely at the bottom, 145.5. 145.
8 and 11.
Your lordship,
Section 8 and 11.
section 8 and 11. Section 8 and 11 of the Arbitration Act. Now, this is the interpretation of the act now by under Vidya Drolia, which takes or goes away from the traditional understanding which was there that 8 is different, 11 is different. Justice Banerjee's judgment also, which says they're slightly different, mandates are different. Here it says mandates are the same. Section 8 and 11 of the Arbitration Act are complementary provisions, as was held in Patel Engineering. The object and purpose behind the provisions is identical: to compel and force parties to abide by their contractual understanding. This being so, the two provisions should be read as laying down similar standard and not as laying down different and separate parameters. Section 11 does not prescribe any standard of judicial review by the court for determining whether an arbitration agreement is in existence. Section 8 states that a judicial review at the stage of reference is prima facie and not final. Prima facie standard equally applies when the power of judicial review is exercised by the court under Section 11 of the Arbitration and Conciliation Act. Therefore, we can read the mandate of a valid arbitration agreement in Section 8 into the mandate of Section 11, that is existence of an arbitration agreement. Now, what I'm on, Your Lordship, is now the law which as propounded here is that the mandate under Section 8 and Section 11 are the same.
But this was in the context of validity of the arbitration agreement.
Your Lordship,
Because if you see 147.3 onwards,
yes, Your Lordship, absolutely, on the validation of agreement, on the agreement. But how the parameters for reference to arbitration has to be the same. That is the line which has been used.
that is
If that is so, then can it be that a civil court which is already in session of a matter under Section 8 and the Section 11 will be heard concurrently, and there can be different ideas, different conflicting issues which can come up. Why? That is why, Your Lordship, I was indicating perhaps it's time now to make a distinction. Like Justice Mukherjee has also made the distinction. When there is a pre-existing suit, in our,
we'll have to attribute some meaning to 8.3 then.
yes, I'm attributing meaning to 8.3. Your Lordship comes to 8.3, shall commence. And that's why Justice Mukherjee's judgment I have indicated. Shall commence, but shall commence, and it says and continue, and then says continue until the passing on of hour. What is that? It has to be differentiated. One is a case where the arbitral reference was already, the proceeding was already.
Cases are covered by 8.3.
Your Lordship,
Both cases are covered by 8.3.
that is what I'm saying also. Both cases are covered by 8.3. One case is when there is a earlier suit, then following Justice Mukherjee's judgment,
Yes.
you will the appointment of arbitrator will happen, but till the suit or the reference under Section 8 is completed, no hearings can continue. No hearing can happen. Another is a case where the arbitration was already continuing and somebody files a suit in between. Because commencement is by a letter under Section 21. Commencement is by a letter. I have filed a suit. You commence by sending a letter. No problem in commencement. Your Lordship will see Section 8.3.
8.3 is very clear, Mr.
Yes, absolutely. But it cannot. Your Lordship, again, I said, that's why I said the Supreme Court.
Despite Justice Mukherjee's judgment.
Despite his judgment. The Supreme Court is also clear when it's on judgments dealing with statutory interpretation, that nothing, no grammatical or clear meaning can be given, can be resorted to if it would lead to an absurd conclusion.
We'll have to read absurdity into the specific, clear, unambiguous language of 8.3 then.
Yes, have to.
And we say we have to deem that the legislature in its prudence did it.
Your Lordship, may I just submit that the legislature otherwise would have said, arbitration will, Section 8 will not be a bar for arbitration proceedings. Here it does not say so. It makes the departure. If Your Lordship sees the grammatical even in that, notwithstanding an application has been made under subsection 1, and that the issue is pending before the judicial authority, and arbitration may be commenced or
Very well.
Or continue.
Get your point. So you say that where the issue becomes the same, I mean, same pertaining to whether it is arbitrable or a suit will lie, then Section 8 and 11 are on a parity, or then it may continue. But in your case, there is no question of, here also there is a Section 8 in your case.
Yes.
In a suit. Very difficult. That is a
Lordship,
very
may I
subtle
just-
line of distinction.
May I just submit?
Very subtle line.
And arbitration, may I just, I am emphasizing on the word or. then arbitration may be continued or commenced or continued. Or
Wider.
no, Your Lordship, on the other hand, it makes a difference of two situations. One, where there is a pre-existing suit, and another one where is no pre-existing suit and where it says shall commence.
No, 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 no. Mr. Sira, subject to correction by you, an arbitration may be commenced or continued, not the suit.
No, that's so exactly.
In either case,
I am also
suit has
saying-
commenced.
No, Your Lordship.
Please read it
Your
properly.
Lordship, supposing somebody files a suit, then you have
There
subsequent-
cannot be subsection 8.1 application unless there is a suit.
Yes.
So suit has to have been filed
Your
for
Lordship,
applicability 8.3.
may I just, a judicial authority before which an action is brought in a matter which is the subject matter of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming
So
suit or
it is a
under it-
prerequisite of section 8.1. Come on. This is very basic.
Your Lordship,
axiomatic.
may I just read this?
You are saying section 8 can be filed before a suit.
No.
Cannot be.
I am saying that one, a suit has been filed. Two cases. Your Lordship, I'm not perhaps being able
The two
to.
cases are not whether a suit has been filed or proceeded continued with. Arbitration has commenced.
I'm just, Your Lordship will just give me a moment to, I'll just explain.
I'll give you 4 minutes. More than that, a bit more. I'll come back.
Here.
I'll come back. এটা দিয়েছে? আচ্ছা, NM global.
Your Lordship, I'll take 4 minutes to finish this point and then move on to the.
Oh, yes, yes, absolutely.
Your Lordship, what I was on was not with regard to when the suit is filed or otherwise. Suit is filed prior in time. I was saying about two situations. The word used is or, shall commence or continue and make. That is the part. The two, if your Lordship.
Yes,
goes in-
yes.
If your Lordship goes into the Arbitration and Conciliation Act. It says an arbitration may be commenced or continued and an arbitral award be made. I was saying that it is possible to make a distinction that these are two disjoints. One which says may be commenced, that is one part, or continued and arbitral award made, that is the second part. Two different limbs, not continued one limb. When it happens, when there is a pre-existing suit, it may commence. When there is a suit which is filed after the arbitral reference has started, then it shall continue and arbitral award be made. Two distinct different situations.
Yes.
In that kind of a scenario, I was stating, your Lordship, and humbly submitting that when it is commenced after a section 8 maybe has to be filed, even if the suit has been filed afterwards. Even if the arbitral reference is already continuing, then also a section 8 can be filed. A section 8 can also be filed if a prior suit is there. It is not that the suit, a section 8 is not required. Section 8 is required even
What
if
are you
the-
driving at? I mean, even if it can commence also, and arbitration may also commence after this.
Yes, commence.
Therefore, even if the suit is filed earlier, the arbitrator, the
Shall
arbitration may
commence
commence.
by a 21 notice,
Yes.
a section 9
So you say that it can be harmonized by saying yes, so section 21 up to that stage, you are disjuncting the two,
Yes.
and in case of it was continuing already, it will continue.
It will
An
continue.
award will be made. That's why award is there also.
Yes.
An award is.
An award is there.
But in the case of commencement, section
so that is
21,
what-
yes. But arbitration proceeding, the proceeding
Hearings.
actually,
Hearings.
very.
Your Lordship, hearings. That is why the justice.
Award may not be passed. I mean, that
Here,
portion
no
is not
hearing,
there.
hearing, no award.
Very.
That it cannot be done. That
Very.
is your Lordship, also the understanding, harmonious construction
All
of
right.
Justice IP Mukherjee's order
Very
that, you can take all the pleadings may be completed, everything can be done, but no hearings can start till that suit is completed. Or if a section 8 is allowed, then arbitration will continue.
So in
Section
case
8
it commences subsequently, the arbitration, then it commences only.
Yes,
But in the other case, it will continue and arbitral award will be.
yes.
Very well. Very well.
That is the distinction, and that is your Lordship. I'm relying upon Justice Mukherjee's
Mukherjee's
judgment
judgment for that.
on that interpretation. যুগল কৃষ্ণ, তোমাকে দিলাম কবেটা? Your Lordship, now I'll come to. Oh, there is, now I will start with the Registration Act because my learned friend had relied upon section 49 of the Registration Act. I may note one thing, Your Lordship. It is not the contention of my learned friends in their arguments that registration otherwise is not required. They have not argued that point. They have not said that 17(1)(b) does not apply. They have not said so. That is not their argument. Their argument is on an exception which says that even if otherwise section 17 it is required, under 49, if it's a specific enforcement, and they're themselves saying specific enforcement, I rely upon that submission also with regard to the other point I said, the Supreme Court judgment quoted by them only, that even if there is a void contract, if they have derived benefit, they can't take that point because the Supreme Court is saying if you are asking for enforcement, then that will not help you. That is their submission. Now, under section 49, the Lordship will come to section 49. Your Lordship, may I just Take your effect of non-registration of documents required to be registered. No document required by section 17, that's the one we quoted, to be registered shall affect any immovable property comprised therein, or confer any power to adopt, or be received as evidence of any transaction affecting such property or conferring such right, unless it is registered, unless it has been registered. Now the proviso. Why so says? Provided that an unregistered document affecting immovable property and required by this Act or the Transfer of Property Act 1882 to be registered may be received as evidence of a contract in a suit for specific performance, your lordship, as your lordship indicated yourself, in a suit, not in any proceeding, in a suit. First point, in a suit may be taken for specific performance, in a suit for specific performance. So if there was an arbitral reference which was going on, or if there was in the suit which is there in the Alipur court, it may be produced as evidence of a contract, but doesn't take away from the fact that it is not registered. It does not take away from the other effects. It may only be produced. This does not say that the registration is not required. Does not say it is not required. And the other aspects of 49 will not follow. It only gives the difference that it may be taken as evidence. If it is otherwise void.
Evidence of a contract.
Evidence of a contract.
Of a contract, yes. Here they're relying on a contract. Or,
evidence of a contract in a suit for inter-party rights.
If it can be taken as an evidence in a contract, in a suit for specific performance, why can't it be taken at the juncture of section 11?
Yes, your lordship. You know what kind of a, first, your lordship, in a suit, because they're talking about evidence. They're taking off evidence in a suit, not in any proceeding. It doesn't say.
Isn't it on a higher footing than section 11? Evidence in a suit of a contract, isn't it on a higher footing than a section 11 satisfaction?
Your lordship, no. I would say they are completely different criterions, because here is with regard to institution of a suit. If here is with regard to, if your lordship takes into the account,
Yes.
this is with regard to institution of a proceeding, institution of a suit. In the nature, on section 89,
Yes,
yes. Institution of a suit. It does not say the institution of the suit will be saved. What it says is, it can be evidence. Why? Your lordship, I'll tell you.
The institution of the suit is not saved, Mr. Sinha. How can you produce it in evidence?
May I? I can. In glaring example would be here. A contract which is otherwise void. Section 65 of the Contract Act, which I showed. Unregistered document. Cannot be looked into. Cannot be relied upon. Otherwise. But with regard to monies which have been transferred to the other party, which has received a benefit, for evidence of that, it can be shown. But are not otherwise. Not for specific enforcement of that agreement itself. Because specific performance of a contract, your lordship, what happens? There are two remedies.
Doesn't section 11 require only the existence of the contract?
Your lordship, existence of a contract. Here it is not existence. It doesn't say it exists. It only says that it can be shown as evidence of what has happened. It does not say that that is a contract which is there.
Evidence of a contract.
Or evidence of a contract. Evidence of a contract.
Can be used as an evidence of a contract in a suit.
In a suit,
can it not be used as an evidence of the contract in a section 11 purpose? For a section 11?
No.
Why not?
I'll tell you. Your lordship, my submission on this would be, it has to be because the contract per se under law, under Stamp Act and otherwise, does not stand. If it does not stand, it is not a contract. Evidence of a contract, but not a contract per se. Here, the Supreme Court, I'll show that provision, paragraph. What it says is that there has to be a contract which is in law, a contract under section 10 of the Contract Act. It does not save that. Section 49 proviso does not save that. The reason for that is there are damages. Otherwise, as I said, under section 65 in a specific performance, if there are some monies which have been put forth,
How is that relevant?
because to show that monies have transferred.
Not that. Here it's stated specifically in the as evidence of a contract in a suit for specific
In a
performance.
suit for, that is exactly.
Damages is an alternative remedy at best.
Your Lordship.
Damages are alternative remedies
Not
at
for
best.
damages, per se, my mistake. For
Or transaction even.
for monies which have flowed.
They are wanting specific performance of that contract,
Yes.
of which, as a prima facie evidence, it can be shown in a suit also without it being registered. So why not as an indicator of whether it should be referred to arbitration under section 11, where section 11 6A is also there.
6A, Your Lordship, is not, as has been argued, is not about existence of just general existence of a contract. Your Lordship, now the law which has been stated now is that it has to be a valid contract. It has to be a valid, which is in terms of the law, something that can be attributed as under section 10, a contract. Because something which is unstamped, which is unregistered, is not a contract itself, which is compulsory required to be contract registered, is not a contract itself.
Mr. Sinha, there's a ratio behind this proviso, apparently. Correct me if I'm wrong. Here, section 49A is, shall not affect any immovable property comprised therein.
Yes,
So the corporeal affecting the corporeal rights of an immovable property is somewhat distinct from enforcing of a right to execute to have a contract executed. That is not corporeal right in the property. Like in a not in a probate, I mean probate is not a right example, but it won't affect the non-registration, won't affect any immovable property comprised therein, means the property, the ownership of the property, or the property physically, the corporeal rights in the property. But a specific performance is of a contract, which is a notional in a sense right, or it may be on document, but it is a notional right, not a physical corporeal right in the property.
Yes.
So even without affecting the immovable property in a suit for specific performance, you can get a decree even in that sense. Because proviso, the ratio justification of the proviso can only be that. Otherwise, why exempt a suit for specific performance? For what particularly? You are relying on that contract specifically.
Yes, I'm.
So, but then why this rider, this proviso? Otherwise, it would militate against the plain provision.
Your
The
Lordship,
only logic can be, it's not a corporate, it won't affect any immovable property. I cannot claim right in the property, right title and interest in the property, but I can seek a specific performance of a contract by which I may get a right in the property. You may say, it may be said arguably, Mr. Sinha, that in a specific performance suit, now a decree is passed, an agreement is executed, a deed is executed. At that juncture, there will be a registration. Has to be, suppose. If it was initially, not registered. Because then at that point of time, after the decree is executed, a specific performance decree, then corporeal rights come in, it would affect the immovable property. But apart from that, there is no scope of affecting in a suit for specific performance. Property is not affected. The right to get rights in the property, that is affected. An enforceable right, you may say.
may I just.
This is a bit subtle, but you are right. You are right that there is a difference between, evidence and whatever. But for section 11, what do we have to see? They are wanting specific performance of a contract. That right to enforce that contract they are wanting. They are not wanting in section 11 is, even in section 9 you may argue this. In section 9 you may argue this. This is not a proof of a contract, prima facie. Although don't do that, please.
No, I would suggest that if the section 11 is not.
This is a very good argument, I must say, because you are saying this is not a scope of, this is not a question of evidence of a contract being laid where it can be justified. Here the contract is being relied on by them for section 11 for reference.
Yes.
But what is the reference for? Again, specific performance comes in.
But Your Lordship, may I just submit this? Doctor, you just give me 1 minute.
Take your time. This is a tricky issue. But Mr. Sinha, I can assure you this is not an absolute opinion. I mean,
No, no,
I'm just opening my mind as it comes.
no, I may absolutely stand corrected because your lordship, this
Both of us
issue-
may stand
this
corrected.
issue is just came up now, so I have also
Issue
not,
of law being argued in court, anybody can stand corrected.
no, this is also an issue because I am,
Sometimes the legislature also stands corrected. Suggestions are made by the court and not followed. That is a different thing. Let us skip over to the next issue, Mr. Sinha. We'll come back to this if necessary.
yes, your
Put it
lordship,
in your written notes, and because you have argued this. Section 49, you have made the argument.
I have made the argument and
They have notice of that. And put it in your written notes, whatever. This argument, please put it in your written notes of argument.
yes, I'll do.
This is a different argument somewhat. Proviso speaks of evidence of contract, and you are saying that section 11 contemplates the reliance on the contract itself.
Your lordship, may I just submit one thing?
Yes.
This is, no, this is, I'm reading from.
Knee-jerk won't do. In this
I-
particular case, a knee-jerk reaction would be
I
correct.
know, it won't
Cannot be correct.
I'll consider this. If required, I'll tell my other side and I'll consider this. I'll consider this.
Let us move on to the next point.
Your lordship, now then I move on
Yes.
to the,
Vidyadrolya, you are done with. I mean,
no, I'll come back.
we'll refer to.
I will come back to Vidyadrolya because your lordship, I indicated that I have in the suit, I'll show that the prayers are also with respect to the power of attorneys, which has to be cancellation of power of attorneys in rem jurisdiction, because that is in rem. Power of attorneys, when I'm giving the power of attorneys,
Yes,
that's
yes,
in
yes,
rem. That cannot be cancelled by an arbitral tribunal. There is a procedure that has to be given notice to, there has to be done.
Mr. Sinha, you can argue the points. You can put it in give the paragraphs, say the paragraphs in open court, and give the paragraphs in the.
I will do.
Because you have made substantially this argument. I mean, need not elaborate much on this because somewhat after 1:15, I'll be somewhat constrained with
Your
time.
lordship, I will not take much time.
After 1:15,
Yes,
not before
I
that.
will finish by 1:15.
You have almost 1 hour. Yes,
I will finish.
45 minutes at least.
Your lordship, because I have to just at this moment only show the paragraphs.
Yes.
So what happened, your lordship, is that all of us had the copy of which was given in India law or of the judgment. Yes. Huh?
Live law.
Live law. Somebody sent me live law.
Oh, these are 5 judge bench.
This is a 5-judge bench. The live law judgment, which was not complete. The concurring opinions were all not there. So yesterday night, I suddenly found that SEC has now reported it, which I have given you now. So now what has happened is the paragraph numbers have changed. So I have made the list so that it can be tallied.
Very, very, I mean, arduous for you.
Yes,
For your junior and you.
after going through entire 300 pages.
Undoubtedly very, very arduous.
Your lordship will come to paragraph 27 of the judgment. Your lordship has the copy of the, not Vidyadrolya, your lordship. You're not dealing with Vidyadrolya.
I'm sorry.
NN Global.
NN Global, please.
Your lordship.
Oh, NN Global, the reference was made in NN Global or Intercontinental?
No, in NN Global.
Oh, that has been answered here.
Yes.
Achha. Sorry, I missed it out. Yes, paragraph 27.
27, your lordship.
Yes, 27.
Paragraph 27. I don't have the page numbers written down, your lordship. Paragraph 27. I think this is the one. What led to the insertion of section 11(6)(a)?
No.
Paragraph 26. 27.
After the question is formulated in paragraph 21, whether the statutory bar.
26, your lordship. 26, 27.
No. After that,
Yes,
there is a caption, the act. And under the act, certain sections are quoted.
Yes, your
And
lordship.
thereafter, there is another caption, what led to the insertion
Yes,
of.
that is the paragraph I'm
Achha,
reading.
very good.
That is paragraph 27.
Oh, reading the caption, I'm sorry.
Yes, yes. What led to the insertion
Yes,
of
yes.
this? It will be 26. Yes, 26. I'll give both the paragraph numbers so that my learned friend can also. No, he
Definitely.
and I have the same copy. Your lordship has the SEC copy, which is a full judgment. So I'll give.
But you
both.
give the SEC copy later on
I have
in your
given you.
written notes.
Oh, with my written notes. Yes, yes.
Yes.
Now, your lordship. This goes on for paucity of time, I'm not going into too
It
much
does
on
go,
this.
go on.
Because this goes on to the entire thing with regard to what was there and what are the judgments which was there. Your Lordship will skip to paragraph 34. Where the paragraph 34,
34 years.
32 for you.
It is accordingly.
Ah, It is accordingly accepting the report that sections 11(6)(a) came to be inserted. This was the 246 Commission report. I didn't deal with that.
Yes,
Your Lordship.
yes.
After having set out the events which led to the insertion of section 11(6)(a), we may take the narrative forward. In Duro Felguera, we have noticed that the view taken in the paragraph 59 in the earlier part of this judgment, in essence, the duty to find out whether an arbitration exists or not. And your Lordship, it sets out next paragraph, Lordship, next
Garware.
paragraph 35, 33 for you. In Garware, a bench of 2 learned judges dealt with the case under section 11(6)(a) itself, and that too in the context of the Maharashtra Stamp Act 1958. Your Lordship, the Maharashtra Stamp Act, Bombay Stamp Act has just 1 or 2 provisions dissimilar, otherwise the same as the Indian Stamp Act. The contention raised by the appellant was that the judgment in SMST estates continues to apply even after the introduction of section 11(6)(a). In other words, notwithstanding the insertion of section 11(6)(a), the procedure contemplated in SMST estates would have to be followed. The court went on to hold inter alia, as noticed by us already, and which has been referred to in NN Global, paragraph 22 of the Garware, when an arbitration clause is contained in a contract, it is significant that the agreement only becomes a contract if it is enforceable by law. We have seen how, under the Indian Stamp Act, an agreement does not become a contract, namely that it is not enforceable in law unless it is duly stamped. Therefore, even in a plain reading of section 11(6)(a), when read with section 7(2) of the 1996 Act, that's Arbitration Act, and section 2(h) of the Contract Act, would make it clear that an arbitration clause in an agreement would not exist when it is not enforceable by law. Your Lordship, I will pause here for a moment. There are 2 things. One is a general assertion of law, that arbitration agreement will not exist when it is not enforceable by law. And the other one is with regard to the Stamp Act, because that is one of the instances where it is not enforceable by law. But the general proposition which is being made out by the court, and which will follow, I'll show has been followed in NN Global, the new judgment, is that when it is not enforceable by in law, section 11(6)(a) cannot be resorted to. This is also an indicator that SMST estates has in no manner been touched by the amendment of section 11(6)(a). And your Lordship, I'll show the provisions on section, though SMST has been already indicated, I will show the provisions paragraphs where it says it's an empty formality to appoint arbitrators in matters where it is unregistered documents. Paragraph 29 of the Garware judgment, it says this judgment in Hyundai engineering case is important in that what was specifically under consideration was an arbitration clause which would get activated only if an insurer admits or accepts liability. Since on facts, it was found that the insurer repudiated the claim, though the arbitration clause did exist, so to speak, in the policy, it would not exist in law as was held in that judgment. When one important fact is introduced, namely that the insurer has not admitted or accepted liability. Likewise, in the facts of the present case, it is clear that the arbitration clause that is contained in the subcontract would not exist as a matter of law until the subcontract is duly stamped, as has been held by us above. The argument that section 11(6)(a) deals with the existence as opposed to section 8, section 16, and section 45, which deal with validity of an arbitration agreement is answered by this court's understanding of the expression existence in Hyundai engineering case as followed by us. That means it has to be of something which can be enforced. Just mere bare existence will not do. Now, your lordship comes to paragraph 35. Sorry, your lordship will skip this portion because they now go into two other judgments, Mayavati trading and otherwise. Your lordship skips to paragraph 38, 36. The view taken in Garwade, that paragraph 22 and 29, which I just read, came to be specifically approved by a bench of 3 learned judges in the judgment reported in Vidya Drolia. That's the judgment, the 2021 Vidya Drolia. Therein, Justice Sanjeev Khanna wrote for the court and Justice N.V. Ramanna supplemented with his own judgment. The judgment was rendered on a reference dated 28 February 2009, and the question was whether landlord-tenant disputes governed by the provisions of the Transfer of Property Act were arbitrable or not. Apart from the said issue, the other quandrum was as to who would decide vis-a-vis the court at the reference stage or the arbitral tribunal in the arbitral proceedings. The court also found it fit to go into the question as to the scope and ambit of the jurisdiction at the reference stage. It is in course of this judgment that he made the following observations. Your Lordship, thankfully, it is all set out, so I won't have to deal with these things in Vidya Drolia. But your Lordship, you'll note paragraph 146 onwards of Vidya Drolia. We now proceed to examine the question whether the word existence in section 11 merely refers to a contract formation, whether there is an arbitration agreement, which is the grammatical understanding of section 11(6)(a), and excludes the question of enforcement, that is validity, and therefore the latter falls outside the jurisdiction of the court at the referral stage. On jurisprudentially and textualism, it is possible to differentiate between existence of an arbitration agreement and validity of an arbitration agreement. Such interpretation can draw support from the plain meaning of the word existence. However, it is equally possible to jurisprudentially and on contextualism to hold that an agreement has no existence if it is not enforceable and not binding. Existence of an arbitration agreement presupposes a valid agreement. Existence of an arbitration agreement presupposes a valid agreement which would be enforced by the court by relegating the parties to arbitration. Legalistic and plain meaning interpretation would be contrary to the contextual background, including the definitional clause, and would result in unpalatable consequences. A reasonable and just interpretation of existence requires the understanding the context, the purpose, and the relevant legal norms applicable for a binding and enforceable arbitration agreement. An agreement evidenced in writing has no meaning unless the parties can be compelled to adhere and bind by the terms. Your Lordship, I have already indicated why under the Trust Act and also the West Bengal Premises Tenancy Act, it can never be done. It can never be done. A party cannot, I continue, Your Lordship, a party cannot sue and claim rights based on an unforeseeable document. Thus, there are good reasons to hold that an arbitration agreement exists only when it is valid and legal. A void and unenforceable understanding is no agreement to do anything. Existence of an arbitration agreement means an arbitration agreement that meets and satisfies the statutory requirements of both the Arbitration Act and the Contract Act, and when it is enforceable in law. So 3, not only satisfied Arbitration Act, not only contract, but all other laws which are applicable, existence in law otherwise, which I have shown it does not conform to. Your Lordship will then continue. And paragraph 147, we would proceed to elaborate and give further reasons. In Garwade, that is the judgment which we are talking about, this court had examined the question of stamp duty in an underlying contract. Your Lordship will first see that first part which I read out of paragraph 146, that is on general law. Then they come to the Stamp Act. It should not be understood that it is only with respect to the Stamp Act. 146 was with regard to general law in particular. 147, now they come to Garwade. After laying down what the law is, then they are coming to Garwade. Because Garwade was a two-judge bench. There were other conflicting decisions, then that's why it's Mayavanti and all. So that's why this court had examined the question of stamp duty in an underlying contract with an arbitration clause. And in the context had drawn a distinction between the first and second part of section 7.2 of the Arbitration Act, albeit the observations made and quoted above with reference to existence and validity of the arbitration agreement being apposite and extremely important, we would repeat the same by reproducing the paragraph 29. Your Lordship. So, and that paragraph was already there.
Yes.
Your Lordship then comes to paragraph 39. This paragraph, Your Lordship, I have already indicated in paragraph. So next is paragraph 39, paragraph 37 for you. 37. It is thereafter.
39.
39, Your Lordship. It is thereafter. Your Lordship is wrong. It is thereafter. That in because Your Lordship, the paragraph numbers are different. That's why
Definitely.
It is thereafter that in NN Global, the court doubted the correctness of the view taken in the aforesaid paragraphs and referred to the findings in paragraphs 22 and 29 in Garwade, which stood affirmed in paragraphs 146 and 147 of Vidya Drolia. We may notice that paragraph 147 of Vidya Drolia purported to give reasons in regard to what was stated in paragraph 146. Paragraph 147 is followed by paragraphs 147.1 to 147.11. However, what apparently the court in NN Global doubted appears to be paragraphs 146 and 147, which we understand in the context of this case is to be confined to paragraphs 147.1.
So, Mr. Sinha, why don't you read 226 directly? Paragraph 226 directly. That is the answer to the reference, which is against you. Which is against you.
226.
226 paragraph.
Paragraph 226 is
this is answer to the reference in a different case.
No, 226, I think, Your Lordship. Paragraph 226.
Yes. It's not
Your
there.
Lordship, Your Lordship, that is a dissenting opinion, I think, Your Lordship is looking into.
Achha.
This one concludes in paragraph 130 or something.
Oh, I'm sorry. Let us see paragraph 130 then.
Because, Your Lordship, otherwise the discussion on the law is there.
The entire thing goes against it. Against the grain of the discussion then.
If that is
If that is there.
that is there. No.
I was wondering. 130, let us come to that.
Your Lordship may just I'll just give me a moment. Paragraph 119, I think. Just Your Lordship will just conclusions. Your Lordship, this is paragraph 109. Sorry, it should be a conclusion 116, paragraph 116 or 17. It should start conclusion. Said conclusions. 119. 119. Your Lordship.
19.
19.
Yes, got it.
The view taken in SMST as followed in Garwade and by the bench in so and so as to the effect of an unstamped contract agreement in arbitration agreement and the steps to be taken by the court represent the correct position in law as explained by us herein above. I'll take you back to the reasoning, but Your Lordship. NN Global was wrongly decided and when it held to be contrary and overruled SMST and Garwade. Thereafter, it says an instrument, Your Lordship, next paragraph.
Yes, absolutely.
An instrument which is exigible to stamp duty may contain an arbitration clause and which is not stamped cannot be said to be a contract which is enforceable in law within the meaning of 2H of the Contract Act and is not enforceable under Section 2G of the Contract Act. An unstamped instrument, when it is required to be stamped, being not a contract and not enforceable in law, cannot therefore exist in law. Therefore, we approve of the paragraphs 22 and 29 of Gadwade. To this extent, we also approve of Vidya Drolia insofar as the reasoning in paragraphs 22 and 29. This is paragraph 146 and 147, which I was relying upon. They approve. This is the decision of the court, Your Lordship. The true in paragraph, next paragraph, the true intention behind insertion of section 11(6)(a) in the act was to confine the court acting under section 11 to examine and ascertain about the existence of an arbitration agreement. The scheme permits the court under section 11 of the act acting on the basis of the original. Your Lordship will see now here.
Original significance.
No, your certified copy. This is the scheme which is now being said to be a binding thing by the court. I told you, Lordship, I'll come back to this.
The importance of the original.
Importance. Here also nobody disputed, but the scheme has been approved by because the wordings of the scheme, here the Chief Justice of Calcutta, there is the Chief Justice of India. The scheme is this, but inside the scheme are the same. I can give a copy of that scheme also, but that scheme is the same document. Wordings are the same. The scheme permits the court under section 11 of the act acting on the basis of the original agreement or on a certified copy. The certified copy must, however, clearly indicate the stamp duty paid as held in SMST. If it does not do so, the court should not act on such a certified copy. If the original of the instrument is produced and it is unstamped, the court acting under section 11 is duty bound to act under section 33 of the Stamp Act as explained herein above. Your Lordship, one thing I'll tell you, though there is a discussion inside of a judgment called Hari Om Chawla, I think the name of the judgment is. That judgment also says if a certified copy is produced and not the original because the party doesn't have an original, then that certified copy can also be impounded under the Stamp Act. There is a discussion on that, the Hari Om Chawla's case. When it does so, needless to say, the other provisions, which in the case of payment of duty and the penalty would culminate in the certificate under 42 of the Stamp Act, would also apply. When such a stage arises, the court will be free to process the application as per law. Your Lordship, thereafter, it's on the Arbitration Act and the stamp duty. But Your Lordship, now that it's that paragraph 200 something is a dissenting opinion is not the yes. I was also very surprised. Then I remembered this one this is a dissenting. There are two dissenting opinions, and I'll tell you.
This was 3:2.
This is 3:2, Your Lordship. There's one concurring opinion, there's one majority opinion, and the two dissenting opinions. Your Lordship, I told everybody that people should read the dissenting opinion. I read all of them.
It's always there.
The dissenting opinion of Justice Roy, which I think is the best judgment of all the three. Because though this is the law now, a question which arises immediately is, though not in relation to this, I'm just saying, what happens to fixture notes when you are doing admiralty matters? There is never a signed contract. An agreement will require 10 rupees stamp fee. There can never be a stamp.
Some other line of distinction will be thought of.
Because Your Lordship,
there does not operate in water.
See,
something like that.
Your Lordship, the thing is, what we in the bar, if this matter was argued, Your Lordship just sees, if this particular matter was argued on the day it was presented and there was no problem with service, this law would not be there. It would be a completely different law. And in global, the earlier one, discounting whether it is not, and now this is a completely different law today. Anyhow, Your Lordship,
wait for the 7-judge bench.
Yeah, that is one after the other. Your Lordship will see the trend which is happening.
There is a difficulty you are facing every day. Everybody is facing it.
Your Lordship, it is true. Your Lordship, today, there is no question of what really the law is. Nobody knows. Because, Your Lordship, and
And ignorance of the law is not a
Not an excuse. It's not an excuse. I always see there, your lordship just gave a judgment on seat and
Oh yes.
I was hearing that discussion. Same argument is being done in another court here only. Same arguments by different lawyers are being done in another court. I was hearing that also.
Why another set of lawyers?
Another set of lawyers.
Acha.
That was being done.
These things have to come in. I mean,
But your lordship, I'll tell you, the concept of seat is alien to domestic arbitration.
true. You are absolutely right, Mr. Sinha, probably, because otherwise, I mean, it does not make any sense.
The reason I'll tell you what has happened.
International arbitration, then it's all right. Yes.
There were two matters which were going on
The
simultaneously.
law which has to be followed is the same.
Yes. Everything is the same.
Everything is the same.
Barring state amendments, 1 or 2 on limitations and otherwise, not everything is the same.
Right.
So it really makes no difference. The law was ABC Laminat and Hakam Singh. Everybody knew that law following the
Yes,
Contract
yes.
Act for 400 years. Everybody has been following that law.
Right.
What happens is in BALCO, 2 paragraphs which are obiter dicta, paragraph 95 and 96. Obiter dicta, there are examples which are given in a matter relating to enforcement under 48 of an international arbitration. Paragraphs are given for something on domestic arbitration. Indus Mobile,
That Delhi, Bombay, that
Indus Mobile, yes. Delhi, Bombay, Calcutta was also.
Calcutta was also there, luckily.
The reason why Calcutta was mentioned is portions of that judgment, if your lordship will see, of BALCO are directly copied from a Calcutta judgment called Canadian Corporation, or Coal India versus Canadian Corporation. The both matters were being heard out together. There were arguments were made here about Austrian law and others and everything. I was there again, so I know. So Justice Banerjee was deciding that. Hearing was concluded in BALCO. No orders delivered till this order was delivered. Went back. That actual story is there are portions in BALCO which were never argued in the Supreme Court.
That is probably one of the reasons he is there, where he is. Maybe one of the reasons.
Maybe one of the reasons.
Maybe one of the reasons, because there are several complexes involved. Anyway.
Very well. Your lordship,
No, I can say here, particularly because there is live streaming now. So I can very well say. Whatever I say, it's in open court then. Now it's really in open court.
So your lordship, as I was, seat, the entire concept of seat was not
True.
there. Anyway,
Right.
coming back to your lordship, will now come back to paragraph 60. I'll just take a minute to get back to paragraph 60.
But I suppose before I pass my judgment on this, probably the 7-judge bench will come. I think so, because it will take some time. This has to be gone through, I mean, meticulously.
Yes, your lordship.
Which is
And your lordship, anytime your lordship wants us to come back, because I have had,
definitely.
because
definitely.
I'll tell you,
It may be necessary.
it so happened that one which I told you at 9:30, I argued with Justice Kathawala.
Yes.
We finished arguments in December of 2019. My solicitor in Bombay was called in sometime in May or June of 2020, after the COVID restrictions had been waived, that we should come back to do the hearing again. And we went back twice.
That's absolutely fair in a sense, not fair on the litigant's pocket maybe, but if the litigant has a pocket, deep pocket, then Mr. Sinha, that's a very fair approach, I think, because court will ponder over the matter basically. So court may think further assistance is necessary or further help or guidance is necessary from the bar. Definitely.
Your lordship, I was very
That
happy.
is what makes the judgments. It has to be there.
Your lordship,
It's not a. I mean,
no, true. What had happened there was in the open court, it was pronounced that section 11 would be rejected in my favor. Then I was told to come back after 6 months, and the Justice Kathawala said that Mr. Sinha, and he sent beforehand, some new Supreme Court judgment had come before he could sign the order. They said, you please come back and distinguish this, then only I can pass it, otherwise my hands are tied. So I had to come back. Be successful, but it happens, it does happen. Your lordship will come back now to paragraph 60, 55, total 55. 60, paragraph 60. I'm just on the reasoning now, your lordship. Only on
yes,
the
yes. You are
reasoning.
there, right?
Yes.
60.
60. The next part of, and your lordship will look at, this is now from paragraph, I think 58, your lordship's, I think 58, the discussion on the Contract Act has started. And your lordship in paragraph 55, it says, the next part of the section 10 to be noticed is the expression parties competent to contract. Section 11 of the contract declares that every person is competent to contract according to the law to which he is subject. So and so I am not going into this much. Then your lordship goes and they notices section 23. It reads what consideration objects are lawful and what not. The consideration or object of an agreement is lawful unless it is forbidden by law or is of such a nature that if permitted, it would defeat the provisions of any law or it is fraudulent. So if it is permitted today, arbitral tribunal deciding whether I can transfer my tenancy rights, whether charitable trust can be doing it, that goes against the tenet of written law. It is forbidden by law. You can only do it by law of by an order of the court, or you can do it after permission otherwise. You cannot do it otherwise. And the very important thing under 5(6) of the West Bengal Premises Tenancy Act is, your lordship, it is not curable. What it was argued that it was curable and may receive that entire thing later because obviously everybody in hand in gloves. Well, it is not. It says prior. It uses the word prior. It doesn't say it's consent. If it was only consent, then it could be afterwards.
No,
also.
prior consent.
Prior consent.
Very clear.
Not there. Not there. So under section 23, it's a void contract. The entire basis was to take away the tenancy rights in the guise of telling some poor people that their charitable trust will be taken care of, school will be run. Nothing was done. Nobody even turned up. Your lordship, I'll continue with the same paragraphs. Now, your lordship, there is an entire discussion from paragraph 61 onwards, which regard to voidable contracts. I'm not going into this because there is no point in going into voidable contracts. Now, your lordship will come to paragraph 67 and 68. 61 for you. Now it deals with NN Global. To the extent that NN Global proceeds on the basis that the Stamp Act is a fiscal enactment and the object is to raise revenue, there may not be any serious room for objection thereafter. As far as the finding in paragraph 28 of NN Global, that is the older one, obviously, that the decision in SMST Estates does not lay down the correct law when it holds that an arbitration agreement in an unstamped commercial contract cannot be acted upon or is rendered unenforceable, we are of the view that the finding in NN Global does not appear to be correct. A perusal of paragraph 29 would show that the court in NN Global proceeded on the basis that the arbitration agreement, being an independent contract, is not chargeable to payment of stamp duty, and it would not invalidate the arbitration clause or render it unenforceable, since it had an independent existence of its own, cannot hold good in view of the admitted position before us that an arbitration agreement in its own right is exigible to stamp duty. This is the law. Every purchase order issue, every fixture note, everything now will require to be done on stamp paper. Because what it's, and this is the standing law, which I have myself argued before, that unfortunate the written law is that an arbitration agreement, and the court is correct on the law, the legislative perhaps change has to be there, because every type of agreement or something notes which are between parties, like telex. There's a 2009 Supreme Court judgment which says telex itself contains an arbitration clause that is a valid arbitration under section 7. So it cannot have a stamp paper. But unfortunately, this is the law, because the arbitration agreement in its own right is exigible to stamp duty. The whole premise of the court in NL Global being that the arbitration agreement not being exigible to duty and it having a separate existence, the commercial contract in which the arbitration agreement is contained being unstamped would not impact the arbitration agreement, cannot hold good. the reasoning in NN Global in paragraph 32 for disapproving of Garwade in paragraph, that is the paragraph of Garwade which I showed, that the arbitration clause would be non-existent in law and unenforceable till the stamp duty is in adjudication and paid on the substantive contract, is again on the premise that the arbitration agreement is a separate agreement under the Stamp Act, which is not exigible to stamp duty, which we have found is not the case in law. Now, thereafter, Your Lordship, it goes on to the schedules and discussions on the fiscal dispute, which again, I think I will not trouble Your Lordship. Your Lordship will come to paragraph 71.
In this particular case, which you are taking, your case,
Yes.
now there was no, it was not on stamp paper at all.
No, 100 rupees stamp paper.
100.
100 rupees stamp paper. But the question, and I show the judgment in this also, here the case was an unstamped document and unregistered document. SMST is not only on unstamped documents, it is also insufficiently stamped documents. It works both ways, unstamped as well as insufficiently stamped documents.
But this logic, if you take this logic on its face value, I mean, for disapproval, that the arbitration clause would be non-existent in law and unenforceable till the stamp duty is adjudicated and paid on the subsidiary contract. Again, on the premise that the arbitration agreement is a separate agreement under the stamp law, which is not exigible to stamp duty, which you have found. What is the stamp duty payable on an arbitration clause?
No, may I just agreement 10 rupees. Stamp normal agreement 10 rupees. No, that is their disapproving. What NN Global had initially, the earlier NN Global had said was that because the arbitration agreement does not require any stamp duty at all, whether the main agreement requires stamp duty or not does not matter.
That clause is the agreement, so
that is enough.
Yes.
Because the arbitration agreement does not require. They are saying that that itself is wrong. They are also saying, as I read out in the previous paragraphs, that the main contract, that's what Garwade as well as Vidya Dolia holds, that and SMST also, that the main contract also has to be sufficiently stamped. It does not mean that there is a contract which is otherwise requires, say, 1,000 rupees of stamp and 10 rupees stamp paper has been used, and that 10 rupees suffices for the arbitration agreement, and so that will be allowed. That is not the issue of this judgment.
So this judgment also refers to Article 5 of the Stamp Act. How does it improve the situation from NN Global? NN Global held what you said. Arbitration clause is a separate clause, separate agreement. It is not required to be stamped. So this.
Yes.
Now it was held in this particular sentence. The reasoning of NN Global, which says that
Is wrong.
is not the case in law.
Yes.
Then it goes on to say, in this regard, we may refer to Article 5 of the Stamp Act.
Yes.
Now, what is it said on Article 5? I mean, how does Article 5 help?
No, Your Lordship, Article 5 agreement or memorandum of an agreement.
What the court is saying in this matter is basically that NN Global is bad in law, in the sense that it said arbitration clause itself is not enforceable, not required to be stamped. Then this says the converse is also true, that the arbitration agreement is also required to be stamped.
Yes. Also requires to be stamped. But it also is saying that it's the main contract, which I read out in the conclusion.
Under which provision it is required to be stamped?
Which,
Under which provision of the Stamp Act is it required to be stamped? An arbitration agreement simpliciter.
under this provision. Memorandum is an
that?
agreement.
I mean-
Your Lordship, it's an agreement. Any agreement, general agreement. There is no specific provision which says arbitration agreement. That's what the court is saying. It is an agreement, that is why it has to be stamped. If you are going to take it as an agreement, then it has to be stamped. And that NN
True.
Global made a mistake on not understanding this basic thing. That is what the underlying reasoning is. They are saying the premise on which NN Global proceeded itself was wrong.
What is 8 annas now? Because C is covered by, if not otherwise provided for, that is there. It's underlined. So that the stamp for proper stamp duty is 8 annas as per this chart. What is the current? Is it more than 10 rupees?
Yes. And no. I think it is 10 rupees under the 1A, which is applicable to West Bengal.
If it is 10 rupees, they have paid 10 rupees.
No. That is exactly what I'm saying. Here, there are two aspects. There are two parts. One is the mother contract itself has to be sufficiently stamped. And the other is that what NN Global said was that because arbitration agreement does not require any stamping, I won't look into the question of the mother contract requiring any stamp. NN Global says yes, the mother contract may not have any
The
stamp.
court has to look into and see.
Yes.
Court has to look into and see
Yes.
whether it's sufficiently stamped.
Yes.
In this document, it's sufficiently stamped then.
No. 100
The
rupees.
arbitration clause is sufficiently stamped.
Arbitration clause is stamped. Your Lordship, may I just submit?
Mr. Sinha, there's a cardinal difference between what you are saying and what has been said here.
No. Your Lordship, may I just
Let me express my
yes.
mind. You are saying that this judgment in a blanket fashion says an arbitration clause cannot be divorced from the main agreement, and under no circumstances can it be said that if the main agreement is unstamped, then the arbitration clause will survive. It cannot be said. But here there is a distinction. The court makes such distinction on the basis that no, that proposition of NN Global is incorrect, because even if the main contract requires a stamp and the arbitration clause itself, it's an agreement in its own right, but it's not sufficiently stamped, then also it's an agreement. It cannot be divorced.
Yeah.
Now, even if it is, I mean, if it's an agreement, the clause, if it's an agreement, so what is the stamp duty you have to ascertain then only on the face of it? So that is 8 annas and you say 10.
Your Lordship, I'm not on that. I'm not.
So then I'll decide that question and say it's sufficiently stamped.
May
I'll accept your proposition.
Your Lordship will let me go through the entire
So
judgment.
because let it not be a futile exercise.
No, it's not a futile exercise. It's not a futile exercise. What, again, let me, my understanding.
Because I
Your
cannot
Lordship,
be academic at the expense of other matters. I mean, I can't afford that.
It is not, Your Lordship.
Yes.
Let me. What NN Global here is saying is, if it is a unstamped or insufficiently stamped document, the mother contract is not talking about the arbitration agreement, then it cannot, no section 8.6.11a reference can be proceeded with. What it says, the NN, to differentiate and hold it bad law, it says NN Global proceeded on a wrong premise itself. It didn't even look into the question of sufficiency of stamp of the mother contract, because it held that the arbitration clause does not require any kind of stamp duty. Now, Your Lordship, I'll come back to this again. I'll answer this question through the paragraphs here only. Your Lordship will come to paragraph 71. Come to paragraph 71. 64. It is true that I have to finish in 10 minutes. I have to wrap up with the SMST also. It is true that in Hyundai, this court was not dealing with the impact of the Stamp Act. The court was dealing with the issue as to the effect of the clause, in which it was agreed that there would be no arbitration if the insurer disputed or did not accept liability under or irrespective of the policy. In the context of the said clause, the court Hyundai went on to hold inter alia that the denial of the plea about its liability by the insurer rendered the making of the arbitration clause ineffective and incapable of being enforced, if not non-existent. No doubt, in paragraph 29 of Gadwade, this court found that likewise in the facts of the present case, it is clear that the arbitration clause that is contained in the subcontract would not exist as a matter of law until the subcontract is duly stamped as has been held by us above. Your Lordship sees again that the arbitration clause that is contained in the subcontract would not exist as a matter of law until the subcontract is duly stamped as held by us above. Therefore, the rationale for finding the arbitration agreement in an unstamped subcontract would not exist. So it is the mother contract, the contract in which the arbitration clause is contained.
Here the subcontract is a mother contract.
Yes, here so the mother contract has to be stamped. Then only this court was only drawing support from Hyundai for the proposition about non-existence of the instrument in law, while Hyundai did not relate to the Stamp Act and even removing the reference to Hyundai. The finding about the existence of an unstamped agreement would be supportable on the reasoning that what is contemplated under section 11(6)(a) is no mere facial existence or existence in fact, but also existence in law. Your Lordship, next paragraph. This court in Garware took the view that unless the subcontract was stamped, the arbitration clause contained therein would not exist as a matter of law.
Subcontract is the mother contract. So
Mother contract. This is what I was arguing, Your Lordship.
Right.
This finding has been rendered apparently on the basis of the impact of the amendment leading to the insertion of section 11(6)(a). Your Lordship, I have already indicated in the conclusion, they have said Garware is correct law. The court in Garware had, in fact, after setting out the law prior to the amendment based on the 246th report of the Law Commission of India, found in paragraph 19 that the Law Commission report did not mention SMST. It is further found that it is for the very good reason that the court does not, while deciding an application under section 11, decide any preliminary issue. The court further found that it was giving effect to the provisions of a mandatory enactment, which enjoins upon the court under the provisions of the Stamp Act to first impound the agreement, and if only the penalty and the duty is paid thereafter, to act upon it. The court had also found that it is not possible to bifurcate the arbitration clause. So there is no question of bifurcating and saying some portion enough
cannot be culled out.
And said that is okay, that much money has been paid, so it cannot be, bifurcation is not possible. We would find that as found by us being unstamped, and Your Lordship now sees insufficiently stamped, the agreement would not be enforceable till it is validated, which is permissible only in the manner provided in the Stamp Act, and till then it would not exist in law.
If it is unstamped or insufficiently stamped.
Insufficiently stamped. Now Your Lordship will come
There
to
is a dispute as to whether there is insufficient
there is no
stamping.
dispute, Your Lordship. 100 rupees is cannot be for a transfer of property, assignment of rights, of tenancy rights. There cannot be any dispute. The exact I have not been able to get that exact how much money.
100 rupees cannot be obvious.
Yeah, obviously cannot be. So on the, Your Lordship now comes to paragraph 67, 74 first.
You are placing 72.
Your Lordship. Sorry, Your Lordship, my mistake. Your Lordship, sorry, my mistake. Your Lordship will 72, yes. Your Lordship,
Finish it in 5 minutes.
I finished 72. Your Lordship was now. Your Lordship will come to 74. However, the said view must be understood in the context of law of limitation, standing in the peril of being. This was in Vidya Dolia, Your Lordship. They came into Vidya Dolia and other judgments of 136 and all. Now, Your Lordship sees, however, the said view must be understood in the context of law of limitation, standing in the peril of being wholly defeated by enforceability of a decree or order within the meaning of Article 136, Limitation Act, being made dependent on an act of volition of a party to pay the requisite stamp duty. Here, in the case before us, we are concerned with the duty of a court inter alia under section 33 and 35 of the Stamp Act, and its impact of its on an unstamped or insufficiently stamped agreement containing an arbitration clause. This is apart from the meaning to be attributed to the words existence of an arbitration agreement in section. This is apart from. This is other duty of the court. Section 11(6). We have explained the concept of enforceability in the context of the Contract Act. What is closer to the facts is the concept of enforceability, or rather the lack of enforceability resulting in the voidness of the contract in the sense explained by us. Now, Your Lordship, only 2 more paragraphs which I have to show.
82 you are placing.
Lordship,
82 you will be placing.
I will be placing 82.
I've read that.
You've read 82.
What other paragraph?
Okay. Your Lordship will come to paragraph 77.
82 is very important. You may read it out so that
Yes, paragraph.
these are the
70
last 2 paragraphs, then you read out.
Yes, 2 paragraphs, paragraph 77 and 82. I'll just read those. 77, Your Lordship.
77 first, yes.
70, আমাদের 70. We would find that an agreement which is unenforceable on account of a substantive law, which would include the Stamp Act, substantive law. Your Lordship, the the Trusts Act.
I know what's the difference between substantive and
No, I'm just saying, I'm just saying that
Please.
both are substantive law, which would include the Stamp Act, would not be a contract. Applying Section 2H of the Contract Act. It is only if an agreement is enforceable that it would become a contract. It is only a contract which would be arbitration agreement, which is contemplated under Section 11(6)(a) of the Act. It may not be opposite to merely describe an unstamped arbitration agreement as a curable defect.
very arguable point, Mr.
But, Your Lordship,
This is a Supreme Court, obviously.
yes, this is, yes. As long as it remains an unstamped instrument, it cannot be taken notice of for any purpose as contemplated in Section 35 of the Stamp Act. And I would say that it's unstamped here, so it cannot be looked into. It remains unenforceable. Section 17 declares the time at which an instrument executed in India must be stamped. The said provision contemplates the stamping of such an instrument must take place before or at the time of execution of the document. No public officer, nor court, nor arbitrator can permit any person to ask them to act upon it or receive it as evidence. In law, it is bereft of life. It is not enforceable in law. In the said sense, it cannot exist in law. It would be void. Our view in this regard, that voidness is conflated to unenforceability. This is fortification from Section 2J of the Contract Act, which renders a contract which ceases to be enforceable void.
82 now.
Just 78 once, just two lines in this. What Section 11(6)(a) contemplates is a contract, and it is not an agreement which cannot be treated as a contract. This is despite the use of the words arbitration agreement in Section 11(6)(a). In other words, contract must conform to Section 7 of the Act. It must also, needless to say, fulfill the requirements of the Contract Act. Now, Your Lordship, paragraph 82, 75 for us. And in Your Lordship, in last portion of paragraph 81, you will see that reference to Hariom Agarwal versus Malviya, that judgment which I was talking about, where Xerox copies was there. Your Lordship, Section 11(6)(a) cannot be understood as merely predicating for an arbitration agreement existing literally. This means that the mere existence of the arbitration agreement for all intents and purposes on the exterior purporting to project a contract duly executed may in certain situations be insufficient under Section 11. If for the reasons such as it being unstamped, when it is clearly required to be stamped, then it cannot be said to be a case where the agreement exists, for it would be no existence in law. While we agree that the court must be careful in selecting contracts when an arbitration agreement which is produced is not to be acted upon for the reason that it does not exist in law, all we hold is that the arbitration agreement which is unstamped does not exist, and an unstamped contract containing an arbitration agreement would not exist as it has no existence in law. And thereafter, Your Lordship, I've gone through the conclusions. Now, Your Lordship, because paucity of time, I'll just rush to SMST, 2 paragraphs of SMST and 1 paragraph of BHATTACHARYA.
Give me the paragraphs. Need not rush to them.
No, Your Lordship, perhaps.
Cite your paragraphs in your written notes.
Your Lordship, may I just one thing I may just read. The only two things I'm going to give it in the paragraphs in the writing. 2 things I'm just mentioning. It says it's an empty formality, and otherwise SMST has 2 parts. One is about unregistered documents, and one is about insufficiently stamped documents. Right. The entire concept of insufficiently stamped documents not arbitrable comes from SMST, approved herein in this judgment in HON'BLE Global. The other aspect of BHATTACHARYA, Your Lordship, is it's an in rem action. In rem parts where are in rem action, and when they are saying the mandate of Section 8 and Section 11 are same, when there are aspects of disputes which relate to in rem, Booz Allen, the judgment in Booz Allen, Booz Allen is there. it cannot be, it is not arbitrable at all, then that is in paragraph 76, it says, in those circumstances, it cannot be referred to arbitration. These are, Your Lordship, my arguments. I will make a more comprehensive note and I will add the
Copy to them.
paragraphs.
When can you do that?
Lordship, just give me some time. I will like
Do it by
for
Tuesday?
Friday, Your Lordship. Will give me by
Friday?
Take some time, Your Lordship. But not before Friday. Friday is, I think, a holiday. And Thursday I'm in Delhi, so I'll try to buy on Thursday. My learned friend will come and give it to the court.
Do that. But you'll have to give them a copy.
I will give them a
so
copy.
that they can use a.
They have heard my arguments, Your Lordship. They know I'm not adding anything else additional.
No, even then. You have to go through that.
I'll try to give them.
So prepare the structure of your notes of arguments.
My lord.
I'll not refer to any other further judgments or anything else. I've indicated what the paragraphs are and indicated
So I'll put it as to be mentioned for filing of the written notes.
on Thursday. I will not
Unless
be there.
Mr. Chaudhary says that he wants to address any of your additional points.
Yes, in case some point, because
So I'll keep it then when? Tell me. Monday week.
No, Your Lordship will keep it on Wednesday. If Mr. Chaudhary doesn't have any additional points, then I will submit it on Thursday. If he has some additional points, then it can be argued any day afterwards.
no. But may I come back and give a reply on Wednesday? And if Lordship gives me 48 hours thereafter to file the note.
Chuti ho jayega. Chuti is Wednesday or Friday is a holiday.
48 working hours. 48 working hours.
Your Lordship,
Yeah.
next Saturday, I'm not there. I'm in Delhi. So
একটা order record করুন হ্যাঁ ওই substantially heard learned counsel for the parties full stop for brief further reply by the petitioner comma if any comma the matter shall be listed on May 3 2023 full stop the Now, further dates will be fixed thereafter for filing of written notes of arguments.
Grateful.
Did not file it on that date, give them a copy. If they file the written notes, I'll do
I'll
too.
try to make it by Wednesday.
Or should I put it, because then respondents' written notes will come earlier than the petitioners.
Yes.
I may direct you to file on that date. I won't permit you to argue further.
No. I'm not going to argue anything. Nothing. I've finished my arguments. Unless new judgments are cited, Your Lordship, they
Don't cite new judgments.
No.
I won't. তাহলে একটা কাজ করুন dates for filing last sentence যেটা বললাম একটু কেটে দিন dates for filing last sentence শুধু এটা কেটে দিন হ্যাঁ কেটে দিয়ে তার বদলে লিখুন the written notes of arguments the final written notes of arguments of the respondents shall be filed on the next returnable date full stop directions for filing written notes of arguments by the petitioner shall be passed on the said date.
Grateful.
Thank you. Whatever judgments you have cited, you have handed up copies. Need not multiply those judgments in your written notes. But if there are any other, then just annex.
There's only one, the Vidya Dolia, which I gave a.
That you can, or I can even see on the internet. I mean, virtual copy. And you annex your written make it very short, please.
Point wise.
Point wise, and as brief as possible.
Yes. We'll try and sum it up within 4 to 5 pages.
No, we need not give an undertaking on that, but please try to do that.
Yes.
Thank you. So then on Wednesday, Mr. Chaudhary, short arguments. After that, your written notes, I'll give a date.
Your Lordship, may I just submit one thing? May I submit my written notes on Thursday? Because I will hear Mr. Chaudhary's reply. They know if my notes are ready already, then it becomes a little.
If you're in difficulty on Wednesday, definitely I'll do. Let it be on Wednesday for filing of your written notes. If it is not possible, then I'll extend that date.
Very
Grateful. Thanks. এই বইগুলো এটার সঙ্গেই থাকবে